Hi guys, how are you? See if I can get myself up here. Hang on a minute. There we go. I'll go up next to this redhead girl. How is everybody? I hope you're having a good day. Just finishing my cigarette and getting into day 2 of this Justin Ross Harris hearing. So what I wanted to do before the hearings, day 2 of the hearing starts, is just read out an original article from 2016 in regards to some of the evidence. If you remember yesterday, I talked about how the detectives in this case lied about some of the evidence, or some people might at least see it as misconstrued and quite deceptive. So an article from Law and Crime in 2016, sorry, my mouse is playing up at the moment, shows that, whoop, wrong one. Where are we? Okay, so prosecutors gave the impression that they had a wealth of incriminating information regarding internet searches that Harris made regarding hot car deaths, animals in hot cars, living child-free, age of consent, and how to survive prison. However, once the evidence was presented at trial, some of it turned out to be fairly worthless, in my opinion. Most of it, if not all. It turns out there was no evidence that Harris searched for hot car deaths, animals in hot cars, or living child-free. What he did do was receive a link from one of his workmates to a Reddit message board called Child Free that he responded to by saying grossness. He also twice accessed a video that he was sent about a vet's discussing the effect of heat on animals. I think we've all seen that video. But there was no evidence that he actually searched for it, like it was sent to him, or that he even watched the entire video. On top of that, police hired a consultant to examine Harris's online activity, and the lead detective didn't even discuss his findings when the examination was over, so they didn't have anything. Some of Harris's online history even played in his favour. We talked yesterday about exculpatory evidence. So that is evidence that favour the defendant. The night before Cooper's death, he was looking at passports because he wanted to take the family on a cruise. He wanted to see if children could travel free. There was even testimony from the travel agent in the original trial. I'm not sure what day it was, but he had spoken to her a couple of times about the passport and booking the cruise. Now, they say a digital forensic specialist, so there was 2 parts there about that if you wanted to watch that, described Harris as crafty because he intentionally hid and deleted information. Now, there's many reasons people do that. Like it says in the article, to make your computer go faster, or it could be the fact that he was cheating on his wife, with 6 other women, sleeping with prostitutes, and he would delete his history so that she wouldn't find it. I mean, that's more likely to me than anything, and then it just talks about sexting with the 16-year-old, which he received 32 years for. I agree with that, the evidence was there, and this is what I want to talk about. I'm really interested in your guys' opinion, who think that he's guilty. I'd love to know, what do you base that on? Have you watched the trial? Did you just watch news reports? what did you watch to make you, and what did you see, or what was said to make you think that he did this with malice and intent. So that's that one. Just waiting for Law and Crime to go live in probably about 7 minutes. The other thing I talked about yesterday was the confusion that the jury might have gotten from the recreation of the car. I'm just going to play you that video, and so you can see how, and I also talked about how the measurements were out by a couple of inches. So I'm just going to show you that video now.
And it shows the movements of Ross Harris that day and shows the measurements and dimensions of the car that was involved, this Hyundai Tucson. But there's one thing in particular that the defense had an issue with. In this rendition, it's a little bit skewed as far as the dimensions. It's a few inches off, so they say that was one misrepresentation. They also have an issue with the way the roof disappears there and makes this vehicle look different, makes it look like a convertible car. And they say that there's impression that these jurors likely got from seeing that, thinking that it was more likely that Ross Harris should have known Cooper was in the back seat if this was indeed a convertible. The defense calling that a lasting mental impression that likely went into the jury deliberations with those jurors.
Yeah.
So that is another contention with this appellate hearing, is that the jurors could possibly look at it, interpret it incorrectly. I don't know what you guys think. I don't know who's here. If you want to say hi, you can say hi. Otherwise, I'm here on my own at midnight. Last night was a long night. It went from, for my time, it went from midnight to 8 a.m. By the end of it, I was in bed, ready to end the stream. I kind of dozed off a little bit at the end. But I found the evidence from Dr. Diamond quite interesting, the memory expert. And I think, I can't remember who was saying it yesterday, you know, and a lot of people say, how could you ever forget your child? And what I was saying was, with the evidence of memory, the hippocampus doesn't discriminate against forgetting a child or forgetting a cell phone or forgetting your handbag, you know. If it forgets, it forgets. It doesn't re-trigger unless it has a cue. And I love this idea of wearing, like, if you have your child in the back seat and nothing in the front seat to remind you to have that cue, I love the idea of wearing one shoe and leaving your other shoe in the back seat, because that is something you're going to notice when you get out of the car. You're going to be off balance. So I love that idea. Yeah, so we've still got about 4 minutes to go. Just waiting for the feed to come on. If you guys want to leave a comment below, if you want to leave say anything in chat or whatever, this is a place where we can agree to disagree. I'm not going to scream at you if you think he's guilty or anything like that. I might try and convince you a little bit, but, you know, that's what we're here for. We're here to debate or, you know, watch and consider the evidence that is presented. And the evidence presented in the trial, I just personally think that it wasn't enough, you know, beyond a reasonable doubt to convict someone of malice murder. It was incredible. And what do you guys think about joinder? What do you think about combining counts 1 to 5, which is the death of Cooper, with counts 6, 7, and 8, which is the texting and lewd acts with an underage girl? Do you think that they should have been tried separately as counts 1 to 5 and then 6 to 8? Do you think the prosecution was right in combining everything? Can you get a fair trial that way? Because that really could have, I think, in the minds of the jurors, made him out to be this bad person. But was he? And he did shitty things. But was he bad enough to purposefully kill his son? Because that's what he's in jail for. So I'm gonna run this feed for as long as it goes today. They did say yesterday that they were ahead of schedule, and that was at about the halfway lunchtime break. I'll leave the stream on for the break, which is usually an hour, and then they'll come back at about 1 p.m. Eastern. So if you just, go and have your lunch or whatever and then come back around about 1 p.m, we should know the times after a little bit. So yesterday they had the memory expert. If you guys didn't see it, Dr. Diamond, he was originally going to testify in the original trial, but he didn't because the prosecution wanted his personal notes. Dr. Diamond worked with the defence, and they had confidential notes back and forth about the case. Now the prosecution can't have those. If Ross had said anything, they could have that. They could legally ask for and obtain those notes. But because these notes were between the expert, Dr. Diamond, and the defence counsel, Maddox Kilgore and his defence team, the prosecution couldn't take them. They could have them if he testified, and that's why they got another expert in, and that expert had no experience about children being left in cars. He only had experience about memory loss. So that, I think, really hurt the defence, and that's something that's only really come out now. We never knew why until yesterday. He wasn't called to testify, and you got to wonder if there would have been a different outcome had Dr. Diamond been able to testify about children left in cars, because he has 15 years experience of that and 40 years total of memory loss. So I think he explained it very well, scientifically in layman's terms, pretty much. And then they had the testimony of Maddox Kilgore, who was the original defence attorney. Not many defence attorneys I like, but I love this guy. I personally thought that his closing argument was one of the most powerful things I had heard in a long time, and to the point where I emailed him, and I don't normally follow up personally on trials and things like that, but I didn't get a response. I mean, obviously, if it's an ongoing trial and it's appellate hearing, he's not going to, email back some random chick in Australia. But I just said to him, your closing argument was amazing. I questioned the jury surrounding, being able to view the car outside the courthouse, having a 360 degree perspective of it. But I was saying, when you saw some of the jury members and that, they were kind of like my height or a little bit higher. And I was like, Ross Harris is like 6'2", 6'3". It's like, did they have like a step that you could put them on to put them at his height so that you're at his perspective? You know, because wouldn't that be closer to the truth of what you're seeing? And then I just showed you that video too. If Law and Crime is running late, I'll play it again for people who have just come in. But yeah, I questioned that. And what else did I email to him? I can't remember. I can't remember the other thing I emailed him. But I was like, if you're looking at that car and you're 5'6", say, you're not his height. You're not 6'3". Your head's not over the roof. And so in the playlist that I have for this trial, if you go to the end and look at the jury questions, so the jury's out deliberating, they come back twice, I think, with a set of questions. And I can't remember what those questions were, but then Law and Crime's running late. I might be able to actually bring that up for you. Look at my history, look, you need to look at Miss Murder's computer. Wahoo. Okay, so all you need to do, is mouse. Just you go to this playlists on here. Oh. And view the full playlist in here. So all the way down here, so many videos. So this is questions that the jury had. And I'll just skip forward a little bit.
Then we have the printed transcript of the defendant's interview with Detective Stoddard. What says the state?
I don't think that they can have the transcript, Judge. I think they can come back in and review the video. I think that would have to be how that goes.
What says the defense?
I think he's right.
Right. Well, I agree. But what note do I write that?
I would suggest if you wish to review the defendant's statement, you'll have to come in here and review the video. Something as simple as that.
Well, I can say the defendant's statement is available in the courtroom video.
I think that's.
Does that work?
Yes, ma'am.
That one, the whole thing was so quiet. It's so hard to hear, but they wanted to see the defendant's statement. Let me just see if this one's any louder.
No technological.
It's no better either. Okay. Sorry about that, guys. That trial was just... the quality was just shocking. Absolutely shocking. I'll have to go back and see what the... I'll watch it with earbuds later and let you know what the jury questions were, because from memory the I can't can't. Hi, Val. How are you? Yeah, listening. Yeah, just waiting for I guess they're running late. I love how the judge says, we'll be back at 1, not 1:15, not 1:10, at 1. And then Ross is back on time, and then she gets back at like 10 past or 1:15. I'm like, come on now. Stick to your own rules. Yeah, so they're running late. Obviously that happens, and especially in this day and age with Zoom meetings and things like that, we're just kind of gotta wait. I mean, I know it happens in a real, physical courtroom as well. Do you guys think we'll ever get back to physical courtrooms, or is this the new normal? Imagine how much money Zoom makes now from this pandemic. I said that the other day to someone. I was like, Zoom their growth must be exponential because everyone relies on it now. There's not a lot of competition out there. And if all the courts are using it, that's just crazy. So, yep, just waiting. Got this on mute. Otherwise there's an annoying beeping sound. So I'm just going to grab a drink refill. Let me just replay this video for you for those that just came in about the car. And how this could have confused the jury.
And it shows the movements of Ross Harris that day and shows the measurements and dimensions of the car that was involved, this Hyundai Tucson. But there's one thing in particular that the defense had an issue with. In this rendition, it's a little bit skewed as far as the dimensions. It's a few inches off, so they say that was one misrepresentation. They also have an issue with the way the roof disappears there and makes this vehicle look different. Makes it look like a convertible car, and they say that there's impression that these jurors likely got from seeing that, thinking that it was more likely that Ross Harris should have known Cooper was in the back seat if this was indeed a convertible. The defense calling that a lasting mental impression that likely went into the jury deliberations with those jurors.
Yeah.
Perfect timing.
The United States and the pertinent laws. There's a deputy in court. The courtroom is open. The clerks are here. The remainder of the hearing is being held via Zoom, and that is consistent with the judicial emergency declared by the Chief Justice of the Supreme Court of the State of Georgia in light of the COVID pandemic. Present on Zoom is the defense counsel, and district attorney's representation. Excuse me, everybody. I didn't do it, and shame on me. So you all also put everything on mute, whatever, mute is the proper term. All right, I think we're ready to resume. Is the defense ready to go? Well, okay. I'll ask, that's a little opposite, but anyway. Mr. Durham, are you ready to go forward?
Yes, ma'am.
Ms. Dunkowski, I'm so sorry. Are you ready to go forward?
Yes, Your Honor, pending sequestration of Mr. Lumpkin and Mr. Rodriguez.
All right, those people need to be sequestered. I believe you're in the midst of your cross-examination. Would you like to resume at this time?
Yes, I would, Your Honor.
Would you please?
Thank you. Mr. Kilgore, can you hear me?
Yes, ma'am.
All right. So when did Dr. Diamond give you defense 1 and defense 2?
Hold on one moment. I may be able to locate something conclusive to that. Hang on just a sec. I apologize. I cannot tell you with any certainty. I just can't tell you with any certainty. It was sometime after, it apparently was sometime after April of 2016.
Okay. And you testified that you didn't really recall the substance of the August 19th, 2016 motion hearing on the state's motion to compel. Is that right?
The August
19th, 2016, the first motion to compel motion hearing.
I have not reviewed that.
Okay. But this trial court did grant the state's motion to compel on August 29th, 2016. Is that correct?
Yes, ma'am.
Okay. And September 6th comes, and I believe the defense filed defendant's motion number 26, which was a motion to reconsider the motion to compel. Is that correct?
Yes, ma'am.
And at the same time, the state also
Its motion
filed
to
the
compel
second
on
motion
August
to compel.
29th,
Is that correct?
Yes.
All right. And so I'm going to share my screen. Are you able to see defendant's motion 26 there?
Yes.
All right. And filed September 6, 2016. Is that correct?
Yes.
All right. And in this motion, right here on paragraph 1, it actually acknowledged that the state is seeking to compel any statement that your client, Justin Ross Harris, purportedly made to Dr. David Diamond. And you understood that that's what the state was looking for.
That's what I have asserted in paragraph 1.
Right. And in addition, when we go down here to paragraph 8, okay, you'd agree that paragraph 8 reads, however, this court's order can be fairly characterized to require the disclosure of far more than the statute requires, including work product, outlines, notes, thoughts, questions, and strategy, or any interpretation of a conversation with the defendant is referenced therein. Is that correct?
Yes.
Right. And did you include this paragraph because you'd had the 3 pages of notes, D1, from Dr. Diamond?
I included that paragraph because it was obvious from the court's order that the order, in my opinion, far exceeded what the statute would require, or the statutes the court was relying on would require.
All right. But you understood that the only thing the state wanted was Dr. Diamond is relying on the statements of Ross Harris to form his opinion. So the state only wants the statements Ross Harris gave to Dr. Diamond upon which he's relying to form his opinion, correct?
It doesn't matter what the state wants. What matters is what the court ordered. And the court's order was very broad. The document that was turned over, the 3-page type document, absolutely fit the criteria of what the court was requiring that we turn over. Because that document, although it was confidential work product and included conversations between counsel and the expert, it also included responses that Ross Harris had given to the expert because he had used the document as sort of a go-by when he went and talked to Ross Harris. So not split hairs, but I mean, I don't just do what the state asked for. I was doing what the court ordered.
Okay.
I was turning over what the court ordered. Regardless of what the state asked for, we were turning over what the court ordered us to.
Okay, so let's go ahead and take a look then at the second motion to compel hearing. You'd agree that that took place late Friday afternoon on the 5th day of trial on September 16th. Is that your recollection?
What was the date again?
September 16th, 2016 It's volume 5 of the transcript, so the 5th day of trial, which was the 5th day of jury selection, late in the evening on Friday. Do you recall that?
That's right.
All right. So I'm going to now share with you. Up here we have them up. Well, I'm going to go ahead and let's see where I'm at. 296. I'm going to go up here and I'm going to show you. So this is September 16th, volume 5 of 35. Is that correct, what I'm showing you here?
Right.
Okay. And so if we go down to, I think,
Right.
page, I'm going to pull this. 1332. On the top of page 1332, we have Mr. Boring beginning his argument after you've made your argument to the court. Is that your recollection?
Right.
So when we go down here to the bottom of this page, do you recall Mr. Boring stating, I will note that the state is pursuing this under 1716-4, not as a statement of the defendant, but as a statement of Dr. Diamond, his statement about and his recording documentation of his conversations with the defendant. That's flat out what we're looking for. Do you remember that?
Yes.
Judge, excuse me, I don't object to the form of the question. Now, she can ask him if that's what was said, but as far as asking him, that's flat out what that they're looking for. That goes beyond his knowledge, or now he's going to speculate what the state has said and or what the state's thinking.
What says the state?
I'm not asking Mr. Kilgore to speculate as to what the state wanted. The state says right here what they wanted. I just want to understand Mr. Kilgore's understanding.
Well, sorry.
I'm phrasing this badly, Judge. I want to make sure Mr. Kilgore's recollection of this motion hearing was brought up on direct. So I'm trying to go through it so that we're all on the same footing as to what happened during the second motion to compel.
She has him on cross-examination, and I don't find the question to be outside of the realm of that. And so you can proceed. Maybe, just go ahead.
Thank you, Judge. I'll try and ask a better question.
So let me answer your question to the best of my ability. I understand what the state was arguing. I understand what is on that paper. But it was certainly our belief all along that what the state was really wanting were the words of Ross Harris. Under the statute, the defendant is not a witness. So they were not entitled to the words of Ross Harris, the recorded statement of the defendant. So they were using Dr. Diamond basically as a straw man to get to the words of Ross Harris. That's what the state was after. We understood that very clearly. That's what they wanted. It's my opinion that this was a mechanism whereby they misled the court as to what it was they were trying to get at.
So, Mr. Kilgore, in your experience, have you ever had an expert witness base their opinion on an interview with one of your clients, such as in a competency or insanity case, where the basis of their opinion is solely upon the words of the defendant, and therefore the state is actually entitled to know what it is the basis is, and if the basis is the words of the defendant, they're entitled to that information, correct?
You're mixing up apples and oranges. There is an entirely different code section, entirely different part of the statute that deals with what is discoverable for an expert witness in a mental health case. That is a different part of the statute. That part of the statute is not applicable here. This was not a mental health case. This was not a mental health witness who was offering an opinion based on a mental health evaluation of the defendant. So I think you're talking apples and oranges. but to the extent that any expert bases his opinion on information that came from interviewing whoever, including the defendant, well, that would be discoverable on cross-examination at trial. That is a rule of evidence, and that is something for cross-examination. That is not a mechanism to get notes of an expert in advance as part of discovery.
So upon cross-examination of Dr. Diamond at trial, if he had been put on the stand, the state would have been able to ask him, what did Ross Harris specifically tell you about this? And he would have repeated that. Is that correct?
Yes, they would have been able to. Well, let me clarify that. The state, I believe, filed a motion. I believe they may have filed a motion to preclude the witnesses from getting from allowing Ross Harris to testify through the words of the expert. In other words, Ross Harris getting his story out without having to take the stand, simply putting an expert on to parrot back what Ross had told him. My recollection is the state had filed something or made some objection to that if that was coming. I don't have that motion in front of me. But to the extent that an expert takes the stand and offers an opinion, and that opinion in any way was based on conversations with Ross, they would be able to question him on cross-examination about that. What I do not believe they are entitled to do is to have those notes as a go-by, those notes meaning the confidential work product that we had to turn over. I don't believe they were entitled to have that as a go-by to question the witness with. I will tell you very directly that we do not allow expert witnesses to take notes to the stand. There is no way we would have ever permitted Diamond to take those notes to the stand. And if you look back at the testimony of Dr. Gene Brewer, that's very clearly stated in his testimony. He said, "Well, I don't have my notes up here. I don't have any notes." That's because we made it real clear you can't take your notes to the stand.
And that was part of your strategy to not have your experts take the notes to the stand.
That's part of any and every case I've ever tried. We don't let experts take notes up there that the state could then grab and use to whatever advantage they want. That's that's kind of like law school 101.
But in this case, the state already knew about the notes, Dr. Diamond having told Mr. Boring on April 6, 2016, that the notes existed. And in the paragraph of the summary of his testimony, it said he was basing his testimony on the conversation he'd had with Ross Harris, correct?
I don't recall, but I think that the expert, we certainly advised him that you can talk to the district attorney and be truthful with him. And it's my belief that that's exactly what happened. I do not believe there is any evidence that David Diamond told the state of Georgia, I have 6 pages of notes and this is what is on there. I'm not going to give it to you. I don't believe he told them that, but he would have told them, well, yeah, I spoke to Ross Harris. We had a conversation. Certainly that has a bearing on what my opinions are in this case.
So what we have here, going back to volume 5 of the trial transcript, where we're in our second motion to compel, you'll notice here that Mr. Boring is once again stating here at line 7 and line 8 on page 1333 that, referring to Dr. Diamond, he has said that he's relying on his conversation with the defendant in his summary. You'd agree that that's one of the arguments made by the state?
What line are you talking about, please?
I'm right here on the screen share, line 7 and 8. He has said he is relying on his conversation with the defendant in his summary, referring to Dr. Diamond.
He made that assertion.
Okay. And we go down, Mr. Boring, again at the bottom here on line 24 and 25, says that, which I think it strains credibility to say that that's not a statement of Dr. Diamond about his conversation about the, and we go down to the next page, line 1, defendant's conversation with him, which he relies on. Is that the argument Mr. Boring was making, that he wanted Dr. Diamond's notes about his conversation with the defendant because he's going to rely on those notes?
So I will continue to answer that the same way that I did. What the state wanted were the words of Ross Harris. They were not entitled to it. And so they used this motion and this argument to make David Diamond the straw man to get to any words of Ross Harris.
Okay, so going on then, we have on the next page on 1335, we have the court at line 3 basically saying that the ruling in August was, in my opinion, the correct ruling, and she hasn't heard anything that changed her opinion, and therefore she denied the defendant's motion to reconsider. Is that the gist of that paragraph by the court?
That's what it says.
All right. Now, out of an abundance of caution by Mr. Boring, you'd agree, because you mentioned it on direct examination, that Mr. Boring actually said, we don't want attorney work product. In fact, he says that right here on line 13. We're not looking for work product of the defense attorneys or anything like that. So we don't have a problem with them redacting things and things of that nature. We don't want to step over that route. I think it's clear what we're looking for. So he actually said, redact away. We just want the thing we're asking for, which is the statements of Ross Harris that were given to Dr. Diamond, that Dr. Diamond's going to rely upon for his opinion. And that's what he said. He said, please redact, right?
Yeah, that is what he said. I think it's pretty clear at that juncture, the state realized, we believe the state realized that they had stepped in it, and the court was ordering something to be turned over that really should not have been required to be turned over. That's how we read that exchange.
Okay. And he then went on to say, if there is an issue and the defense has an issue, I have no problem with them redacting it and we can take it up later. Is that what Mr. Boring told the court?
That is what he said.
Okay. And then the next page, Mr. Boring continues. So I'm at the bottom of 1335, the top of 1336. And his concern was, well, Judge, I know they put in there about attorney work product. I'm assuming, and you correct me if I'm wrong, that he's referring to the motion that we previously looked at, your motion to compel, your paragraph 8, correct?
I'm not going to get into what his mind was there, because that I truly don't know. I assume that he was talking about our motion.
Okay. And he then says, I don't want there to be any attorney work product that they think are somehow, if they're going to turn it over and say that this ordered attorney work product. And the court then said, I stand by what I just said, all of it. Okay. So when the court says, I stand by what I said, all of it, you only needed to turn over the statements of Ross Harris that Dr. Diamond was going to rely upon, correct?
No.
And
we needed to turn over what the court ordered, all of it. The document that was turned over was, as I testified yesterday, was not compiled in a single setting. It was a compilation of sitting down with the attorneys, and Dr. Diamond took that apparently into the interview room and then added to it with either responses of Ross Harris or his own thoughts or opinions about something that Ross had said. So that document clearly, without question, fell within the all of it that the court's original order to compel contained. The order was very broad. And the court was very clear. She did not stutter. She did not make it conditional in any way. She said all of it. And so we complied with the court order. She was already frustrated that we had not turned it over earlier. And so we turned over what the court ordered, all of it.
So when the court says, I stand by what I just said, all of it, you didn't take that to being she stands by what she said, all of what she said, meaning in my previous order, I'm standing by that.
I knew exactly what the court meant. She meant all of it. All of it relating back to the original order, which again was very expansive.
And give me a moment. Are you currently seeing the order on state's motion to compel, Mr. Kilgore?
Yes.
And right here in the middle of the state's order, it says, further, as defendant intends to call Dr. Diamond as an expert witness, Dr. Diamond will be required to disclose any and all of these statements and writings on cross-examination by the state. And the court finds that pretrial disclosure, meaning the statements and writings, is required, or is necessary, I apologize, is necessary to allow the state an opportunity for meaningful cross-examination. And basically what she says up above here finds that any and all statements and writings memorialized in any manner regarding Diamond's conversations, interviews, and discussions with defendant in this case are discoverable. And based on this order, is it correct that you handed over defense 1 and defense 2 to the state?
Yes.
Okay. And directing your attention to September 19th of 2016, is that the day that you did comply with the motion and gave the state defense 1 and defense 2?
If that was the following Monday, then yes.
All right. And do you recall on the morning of October 4th, right before opening statements in this case, that the state went on the record confirming that they'd received it, but out of an abundance of caution, had not looked at the handwritten notes, but in fact had looked at D1 and were going to go ahead and review D1. Is that correct?
Yeah, I remember thinking that it was ridiculous that the state did its own in-camera inspection by itself. If it was worried that there was something it shouldn't see in there, it certainly could have asked the court to do an in-camera inspection, and it did not.
And at no point in time did you ask the court to do an in-camera inspection on D1 and D2?
No, instead, I filed motions to reconsider and made a strenuous argument against turning over these documents.
You'd agree with me that at absolutely no time on August 29th or during the second motion to compel on September 16th, did you tell the court or anyone that you considered these notes to be, as you said, confidential work product notes between the defense attorneys and the expert?
I don't recall how I pled it. I don't recall how I pled it. You talking about in the pleading?
No, I'm talking during your oral argument, when you're in front of the judge during the second motion to compel. Not once did you assert or state that what you were being forced to hand over, that you considered it to be attorney work product. You'd agree with that?
I think it was in the pleading. During the argument, I was making legal argument, which I stand by, that it shouldn't have had to be turned over legally within the statutes that the court was citing, or that the state was arguing.
Okay. What I'm asking you is, you'd agree with me that you never orally, verbally told the court that you considered this document, D1 and D2, these documents to be confidential work product notes between the defense attorneys and the expert.
I may not have argued it orally while I was making my legal argument.
All right.
But Ms. Dunkowski, let me
I'm
point
sorry,
out
Judge.
that
I apologize, Your Honor. I'm really going to object.
I agree.
And the reason I'm objecting is I'm just trying to ask Mr. Kilgore certain questions, and Mr. Kilgore has a tendency for soliloquy. And I would just ask for some direction from the court, especially since he seems to want to just volunteer information without a question being posed to him.
You just need to interrupt him and I'll say yay or nay.
Thank you, Judge.
But cross-examination elicits more of an answer than a direct, well, that's not exactly the case. I would say craft your questions carefully if you consider that to be a problem. That would be what I would say.
Thank you, Judge. I will.
Yes, ma'am.
All right. So, Mr. Kilgore, Dr. Diamond was not prevented from testifying via an exclusion or some ruling of the court. Is that correct?
right,
And you could have put him on the stand to testify. Is that correct?
he was available to testify.
All right. So directing your attention now to November 3rd of 2016. Do you recall that as the date that Dr. Brewer testified, the 29th day of trial?
I don't remember specifically what day it was, but it was toward the end of the trial.
All right. And who conducted the direct examination of Dr. Gene Brewer?
I did.
And he was on the stand all of the morning, wasn't he?
I mean, he testified probably half a day or close to half a day.
All right. So if the trial transcript reflected that his testimony was over at 11:48, do you feel that's accurate?
I don't have any reason to doubt the transcript.
Okay. And do you recall at that time asking the court if you could have a break in order to discuss with the other lawyers and the witness whether or not you were going to put him up on the stand?
Right.
Right. And then a recess was taken from approximately 11:57 to about 1:10. Do you recall that?
I'm sorry, I have a question. You said him. So Dr. Brewer's been on a witness stand. He comes off at 11:48 or so. Defense asked for a recess to review whether they're going to put him on the witness stand. Who is the him?
Very good question. Mr. Kilgore, who's him?
David Diamond.
All right, that's what I thought. I just want to be sure.
Thank you, Your Honor, for helping me with that and clear that up. So the recess was taken from 11:57 to 1:10 p.m. Is that correct?
I have no reason to doubt the transcript there.
Okay. And where was Dr. David Diamond at the time Dr. Gene Brewer was testifying?
You know, I've thought about that and I absolutely cannot remember. I just cannot remember. I want to say he was in the courthouse, but I can't remember.
To the best of your recollection, did you then meet with Dr. Diamond at lunchtime?
I cannot remember. I cannot remember. I just can't.
Okay. So during that hour lunch, did you meet with Mr. Rodriguez and Mr. Lumpkin to discuss putting Dr. Diamond on the stand?
Well, we absolutely, that would have been something that we discussed because that's obviously the time that I pulled the trigger. So I can't remember where we were, but or any specific conversation, but we absolutely would have talked about it.
All right. Because my next question was going to be, what did you guys talk about specifically? But you're saying you don't have a recollection of the specific discussion with Mr. Lumpkin and Mr. Rodriguez about the pros and cons of.
Well, sure. There had been, I mean, from the time we had to turn those notes over, there had been conversations with them about the ability to now use Dr. Diamond. And at the end of the day, it was, I was the one that was going to have to pull the trigger. And so I certainly ran things by both of them. But specifically what we talked about 4 years ago during a lunch break, I couldn't tell you at this date.
Okay. So after running it by Mr. Rodriguez and Mr. Lumpkin, what was your decision?
We did not put him on the stand.
And all right. Now, once you decided not to put Dr. David Diamond on the stand, I think you let him know that he was not going to testify. Do you recall that conversation with him?
I do not recall a conversation in the courthouse. It's my belief that I had told him the day before that he was not going to be called. That's my recollection.
Okay.
That I had told him the night before that he was not going to be called as a witness.
But he was present in the courthouse on November, let me make sure I have the date right, November 3rd, 2016, in anticipation of him being the witness called that afternoon, correct?
No, I would disagree with your assertion there. He was in Glenn County. We had brought him up from Tampa and he was there. We continued to prep him as if he were going to testify. Trials are fluid and you don't know what's going to happen from one witness to the next, from one question to the next. So until you actually pull the trigger and make a decision, either calling a witness or not calling them, you continue to keep all of your options open.
Okay. So I just want to make sure. On November 3rd, you put Dr. Brewer on the stand. You then made your decision, as you call it, pulled the trigger over lunch, and then you told the court, I don't have any other witnesses for this afternoon. Is that correct?
That's right.
Okay. And so Dr. Diamond, though, was prepared and was in the courthouse on November 3rd in case you decided to put him up on the stand that afternoon.
To the best of my recollection, he was probably at the courthouse that day. To the best of my recollection, I told him the night before he would not be testifying.
Okay. And what were the reasons you gave him for why he would not be testifying?
Well, I gave him lots of reasons. Included, obviously, was the fact that his notes had to be turned over. That the court had ruled against us on our subpoena to obtain FBI files that were in the possession of the police department and the Cobb County DA's office. That the court had ruled against us in several evidentiary rulings, and we were not confident that the court was going to rule with us if the state objected to any parts of his testimony. That the state's case had been lousy. I mean, there were lots of things that we talked about with him. I mean, he is an esteemed professor and the expert of experts in this field, but in a professional relationship that we had, I certainly wanted to let him down easy. And I think the best way to let him down easy was to give him as many reasons as possible why we had decided that it was not a good idea for him to testify. it was not his decision, it was mine. And all I can tell you is that regardless of whatever conversations we had with him or even amongst the lawyers, at the end of the day, my decision not to call him was based on the fact the court required us to turn those notes over.
Right. So moving on now to the issue regarding Detective Sean Murphy and the search warrant testimony. However, I did miss one thing I wanted to ask you about with the PowerPoint. The 50-slide PowerPoint that Dr. Diamond had developed that he was anticipating testifying to. Do you remember when you received that from him?
I could not give you a specific date from memory.
All right. And you do recall, though, despite there being no certificate of service in the file, you remember sending it over to the state or giving the state a copy?
Yeah, it was a demonstrative aid. We would not have done a certificate of service because it was not going to be a piece of substantive evidence. And the state knew about it already. I think we had, I think maybe the original PowerPoint, we may have put on a discovery sheet that was included with some other materials, but the final PowerPoint, we didn't do a discovery filing for it, but we absolutely gave it to Prosecutor Chuck Boring.
And do you recall, I think you already testified, I just want to make sure that Chuck told you, Mr. Boring told you that he did have some objections to some of the slides.
Yes.
Thank you. All right, so when we talk, I am going to actually transition now. When we talk about calling Detective Sean Murphy, the state didn't call Detective Murphy in its case in chief, is that correct?
They did not.
All right, and the state did, though, call Detective Phil Stoddard as he was the lead detective.
That is correct.
All right, he was on the stand about 4 days. Is that right?
I don't remember. It was several days.
All right. And you attacked him quite efficiently in your opening statement, talking about how you questioned his credibility. Is that right?
Credibility was central to our defense, and so that's why we covered it so thoroughly in opening.
All right. And do you recall your opening statement was on October 5th of 2016?
That sounds about right.
All right. And then closing arguments, you also brought up these points again to reinforce them as part of your strategic theory of the case.
That's partially true. I brought up those things which we were allowed to go into during the trial of the case. During closing, I did not go into the the lies that were given to the magistrate to obtain the search warrant because we were not allowed to. We were not allowed to bring that evidence before the jury.
Well, what I was asking Mr. Kilgore was regarding Detective Phil Stoddard. Talked about him in opening, and you also talked about him specifically in closing.
Yes.
Okay, and your closing argument, that was November 7th of 2016?
That sounds about right.
Okay. And as part of your strategy during your opening statement, you played actually 3 video clips of Ross Harris's statement, didn't you?
Yes.
And I found 7 different times where you talked about Detective Stoddard and asserted that he lied under oath. Does that sound about right to you for your opening statement?
I don't know how many times, but he did lie, and so we did bring it out in opening.
And you cross-examined Detective Stoddard about all those issues, is that correct?
To the best of my recollection, we covered all of those credibility issues with Detective Stoddard.
And in fact, you did try and bring up, you tried to question Detective Stoddard about what Detective Murphy had said to the magistrate judge when applying for the search warrants, right?
Yes.
All right. And the state objected to that, is that correct?
Yes.
Okay. So I'm going to go ahead and share my screen right now. There we go. So taking a look here at volume 22 on October 25th of 2016. Can you see that, Mr. Cooper?
Yes.
All right. So do you recall this bench conference?
I do.
All right. And this is where Mr. Boring is objecting to the hearsay. Is that correct?
Yes.
All right. And his objections were about going into the contents of the search warrant affidavit, all which were not done by Detective Stoddard. He then told the court he had some case law on that. And then he said, B, it's hearsay if it is a statement of other people, not this detective. And he reiterated there's no lead detective exception to the hearsay rule. Is that fair?
Yes.
And then he said the defense can call Detective Murphy, and then if it's relevant, it cannot be hearsay. Is that what Mr. Boring said?
Yes.
Okay. And is that when you made your decision to call Detective Murphy?
Yes.
And I believe it was actually Mr. Lumpkin who did the cross-examination of Mr. Murphy or Detective Murphy. Is that correct?
Yes.
All right. And if I may have one moment, Your Honor, to see if there's anything else. I may have one more moment, Your Honor. I'll pass the witness. Thank you, Your Honor.
Redirect, Mr. Durham.
Yes, ma'am. Sorry. Mr. Kilgore, how are you today?
Good morning.
Okay, let's kind of I was going to say just go back from yesterday and work our way forward now. And yesterday you gave testimony, and the state asked you about your opening statement. Do you recall that?
Yes.
And you were asked about Dr. Diamond. Well, actually, you were asked if you included Dr. Diamond in your opening statement.
Yes.
And his name was not mentioned in the opening statement, was it?
No.
And you just mentioned an expert.
Yes.
Okay. Had you been ordered and already turned over the notes that Dr. Diamond and his work product and the guideline by opening?
Hold on, please.
Where is it?
Mr. Durham, I'm going to need some help there.
All right, well, let me ask this if I can. Do you recall your when you gave your opening statement? Do you remember when you did that?
Yes, that was. I apologize. Give me one moment. I've got the transcript here. Let me see if I can find that, please.
Okay.
Yeah, the opening statement wasn't given until volume 10. And I believe that the notes would have been turned over several days earlier because I believe that matter was discussed in volume 5.
And do you recall when right before you gave opening, was that when Mr. Boring informed the court about their, I'll use the air quotes, in-camera inspection and sealed a portion of the notes in an envelope?
That timing sounds about right.
And that would have been sometime in October.
That would have been October the 3rd.
Okay. And did you file your disclosure sometime in the middle of September? I think September 16th or 19th. Do you recall?
That's
that?
right. Yeah.
Would that have any bearing on why Dr. Diamond's name wasn't in that opening?
I don't have any specific recollection, Mr. Durham. I just don't have any specific recollection if that had any bearing or not. So I guess my answer is it certainly could have, but I just don't. I don't recall whether that factored in or not, sir.
All right. You were asked about Dr. Diamond's potential testimony and about the state could have been objecting to the portions of the PowerPoint. And do you recall that question?
Yes.
Now, do you also recall in the conversations with the state about when Mr. Boring announced to the court that y'all had provided the transcripts, or excuse me, the PowerPoint to them, they had some objections and y'all would just resolve the issues at a break? You remember doing that?
Yes.
Would that have, and is that what y'all are doing, is working together and trying to resolve the issues before you went to court and try to make the trial run smoothly?
Yes.
Now, the summary that you provided back in April in 2016, that summary was before the motion hearings. Do you recall that? If that was?
Before which motion hearings?
Well, the motion hearing to the motion to compel, the motion for ultimate issue, and the motion.
Yes. Yes.
Okay. And so your summary was done before the court made the ruling that Dr. Diamond couldn't testify to the ultimate issue of the case.
True. That's true.
And then your cross-examination, or your attempted cross-examination of Detective Stoddard, did there have been any benefit? You stated yesterday that part of it, if I recall, of some of the reasons why you wanted to cross-examine him and why you thought that you should be allowed to. But would there have been any benefit to find out where the false information that Detective Murphy provided to the magistrate? Would there be any benefit to y'all in your theory of defense?
Of course. Absolutely.
As far as the source of it?
Absolutely.
Tell us how.
Well, we know that Detective Murphy gave false testimony to the magistrate under oath. Of course, the state's states claiming that, well, he was just parroting something else that he had heard, so it couldn't be a lie because he was just testifying about something somebody else told him. Well, we know that he gave that false testimony to the magistrate immediately following Detective Stoddard's interview with Ross Harris. So, more than likely, one of two things happened. Either Murphy listened in on that interview or Stoddard
calls for speculation as to what took place.
Judge, I think he is, if I can respond, I think he's explaining what his strategies are and what the decisions he made at trial. And I think this is part of it, is how they were deciding to proceed.
He didn't couch it as such. He's speaking as if it's fact, and it would be speculative, and I sustain the objection.
And as far as
I'll try not to speculate.
What were you thinking? What was your concerns?
Our concerns were that if Murphy was not knowingly lying to the magistrate, then some other detective had given him false information. Either way, it's the police department. It is the detectives that are lying about what was said in that interview room in order to further their narrative, and in that particular instance, in order to obtain a search warrant.
And you'd mentioned something about the timing of the search warrants in your investigation of the case, the timing of the search warrants as to when the in custody interview of Ross Harris was. Does that tie into this?
Absolutely.
And again, explain how.
Well, we know that some of the search warrants were requested immediately following the interview with Ross Harris, and they contained references to the interview with Ross Harris. Those references contained statements which were false. They said that Ross Harris had stated, or Ross Harris had said, certain things that in fact he had not said and he had not stated. They were attributing false statements to him, which were very nefarious and damning, but untrue.
And that would help in furtherance of your theory of defense?
Yes.
You can find that? Okay. Now let's go back over the Dr. Diamond, the motion to compel. Now, in his interviews, do you recall when the second interview, that would be the one with the typewritten notes from your testimony yesterday, do you recall when that would have occurred?
So, Mr. Durham, I looked through my files yesterday, which are numerous boxes, and what I discovered was a notation that there was a lengthy interview on August the 10th, 2015. My notes indicate it was 3.5 hours. In trying to reconstruct this, it is my opinion that is very likely the first meeting where we went to the jail with David Diamond. So I think that my characterization as a meet and greet was probably not entirely accurate. According to my notes, it was a very lengthy meeting. I then looked to see if I could verify when the second meeting was with David Diamond and Ross Harris, and I simply could not verify it. I couldn't find anything to verify the exact date of the second meeting.
Now, do you recall looking at the typewritten guideline of that off of Dr. Diamond's laptop?
Yes.
And does the date of April 30th ring a bell? 2016?
I see the date on the document, but I didn't type it, and I couldn't tell you why that date is on there or what significance it is.
All right. Do you know, as far as your recollection, would the motion to compel that Chuck Boring filed seeking the notes in his conversations with Dr. Diamond, would that have been before that April 30th date?
No, I believe that he filed that motion after April the 30th. I don't have the filing date in front of me, but I believe he filed it after that date.
Hang on 1 second.
Seems like he maybe filed it, and I don't. It was after that date, surely.
Now let me just, if I told you there was a filing date of April 11th, would that ring a bell?
Do you have the document I could look at?
I'm trying to figure out a way to get you to look at it.
Would it assist you if I put it up?
Yeah, I've got a file. If you could give me 1 moment, let me see if I can find it.
All right, it's on the screen. Thank you, Mr. Tomkowski. Appreciate it.
You're welcome.
Yes, ma'am. Can you pull it down where I can see the rest of it, please?
Of course.
Okay. 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 So I guess, Mr. Durham, I guess let me answer that question again. It certainly appears that the state had filed the motion to compel prior to that date on the document, April the 30th.
Okay. And let me ask you this, would it appear then that the conversations Mr. Boring had with Dr. Diamond that were the basis of the motion to compel would have been dealing with the handwritten notes as opposed to the typewritten guideline?
I couldn't answer that because I don't know when they were prepared.
Okay, all right. But you would agree if the April 30th was the prepared date, then the typewritten notes could not have been what they were referring to if they were not created before April 11th.
That would be true.
Now, you mentioned it was a 3.5 hour meeting, that first meeting with Dr. Diamond.
My notes reflect that occurred on August the 10th, 2015. That's what my notes reflect.
Okay, but I mean, my question is more around the time frame. You said it was 3.5 hours, so that's again more than a meet and greet, and that was the one with several people involved. Is that your recollection?
My notes say that it was a meeting with the expert David Diamond and Ross Harris at the jail.
Now let's go back to the motion to compel. The state had asked you about some questions about what Chuck Boring had told the court. Now, and he did, and you read on the transcript that he mentioned about the possibility of redaction and offered that to the court. Do you recall that?
Yes, sir, he did, because that's what was in my pleading.
So my question is, so you were asked if you made any reference to it in your argument. Did you find a need to, or was the issue already out there on the table?
I pled the argument in my pleading. The argument I made orally in court appears to be more legal in nature. Mr. Boring apparently took up the mantle for redaction, or for the fact that we had asserted that there was some privilege, attorney work product or confidential work product in there, and the court was not apparently. The court said all of it.
Okay, so you brought it up in a pleading, specifically stating work product. Is that your testimony?
Yes.
And at the hearing, it was brought up again in front of the court. Is that correct? Is that what
Yes.
Okay. Now, do you recall when they were talking about all of it, and your statement was that you believe she meant everything?
I believe what she meant was it referred back to the original order on the motion to compel, which was worded very, very broadly. And in my pleading in the motion for reconsideration, I believe I touched on that it swept up a lot of stuff.
Do you recall when Mr. Boring mentioned the possibility about redaction, and the judge said, well, you invited that? Do you recall that statement about the judge?
Yes. Yes.
And was that right before she said, I stand by it?
Yes.
Okay. After that, did Mr. Boring ever make a offer to you to consent to allow you to redact it?
No.
Did he ever say, well, why don't we just have the judge do it in camera?
No.
Now, your recollection on the day that they came back in and said they had somebody look at it, your recollection is they provided the handwritten copies to the court is something they were not going to look at. Is that correct?
That sounds right.
What was your bigger concern out of those two sets of papers?
Obviously, the handwritten notes. The handwritten notes is all I was worried about, because those were, because in addition to the statements of Ross Harris on there, the bulk of it were reflecting attorney work product, which was, conversations between us and David Diamond.
All right. But now, which ones we've gone over yesterday of D1, and that do you recall that? Was D1 the handwritten notes? Judge, if I could ask the clerk to put up a D1, please. Ms. Kilgore, there's D1 right there. In front of you has been marked for D1 admitted. Is that the one you were concerned about?
Yes, sir.
Okay. And the other 3 handwritten pages, do you recall seeing those in the past?
I saw them.
Were you concerned at all about those?
I was not.
Okay. And you can take it down. Thank you very much, Brett. When you met with Dr. Diamond, the first time you met with him, you were in the room with him? Do you remember that?
The first time I met with
the first time Dr. Diamond met with Ross Harris, you were in the room with him?
Yes.
Okay.
Yes.
Do you recall if Dr. Diamond took any notes or anything at that time?
My recollection is he had a laptop. So yeah, he had a laptop because we were in an interview room at the jail. He carried that laptop everywhere, everywhere.
Now, you were talking before about the not putting him on the stand. Did you have, and you mentioned some reasons that you had talked about. Was there a controlling factor in the decision about not calling him?
Yes.
What was that controlling factor?
The court's order requiring us to turn over those confidential work product materials.
And whose decision was that?
The court's.
Okay, but whose decision was it not to call Dr. Diamond?
Well, at the end of the day, I was lead counsel, so I'm the one who made the call.
And you're the one that talked to Dr. Diamond afterwards?
Yes, it was me.
What was his demeanor?
Well, he was disappointed. He was hurt. Frankly, he was hurt and he was disappointed. And I mean, I tried to give him as many reasons as possible to make him feel better about it, but he was very, very disappointed. He had a lot of emotional investment in the case and wanted to do right by the truth.
Thanks. I don't have anything else. I said thank you.
You're welcome.
Your Honor, if I may have a few more questions.
Yes, go ahead with recross.
Thank you. So, Mr. Kilgore, on August 10th of 2015, you said there was a 3.5-hour meeting. Was that all at the jail? Some of it at the jail? Could you tell us about how much time you spent actually meeting with Mr. or Dr. Diamond and then going to the jail? How did that all work out?
Yes. So what my notes reflect is that meeting was at the jail. That does not encompass other times we met with him at our office or breakfast or whatever. My notes say at the jail.
At the jail. All right. And this is where you're in the interview room at the jail. And I think you said it was yourself, Mr. Rodriguez, your investigator, and Dr. Diamond. Is that correct?
To the best of my recollection, hang on one sec. Let me check something. My notes actually indicate Mr. Lumpkin was there too.
So the entire defense team and the investigator and Dr. Diamond in the interview room with Mr. Harris.
That's what my notes reflect.
Okay. And when Dr. Diamond had his laptop out, was he taking notes about what Mr. Harris was talking about?
I wasn't looking over his shoulder to see what he was typing, so I would not be a good historian for what he was typing.
And I don't really expect you to be looking over his shoulder. Did he have the laptop up, and was he in fact typing during the meeting with Mr. Harris?
To the best of my recollection, his laptop was open and he had it open working.
And to the best of your knowledge, at that meeting on August 10th of 2015, you didn't record it in any way, like audio or video or anything like that?
Absolutely not.
All right, that's all I have. I'll pass the witness. Thank you, Judge.
You don't know what, as far as Dr. Diamond's was doing when he was at the interview with his computer?
I do not.
Okay.
I don't know. I mean, presumably if he'd taken any notes, I would have them. He would have given them to me. So he either was not taking notes or he was making notes of something that was discarded, or, I mean, that's, I don't know.
Okay, then, okay. Now, do you know if he had any do you know what he did to prepare for that meeting? And if you don't, I mean, I don't want you to speculate, I guess is what I'm saying.
I cannot recall at this time whether we met with him in our office prior to going to the jail or we met with him after going to the jail. I don't have a clear recollection of that.
Was that the first time he was in Georgia?
I believe that it was.
Had y'all been to Tampa at that time?
Not yet. We later went to Tampa.
Was this when he was first starting working with you guys? It was been officially retained?
It was his first trip to Georgia. It was his first trip here. We had been providing him information in advance of that meeting.
And you had testified yesterday that this discovery was ongoing and learning things was ongoing throughout this case.
Yes.
Okay. All right. Thank you. Nothing else.
Anything further from the state?
No, Your Honor.
All right. Witness can be excused.
Thank
Mr.
you.
John, what would your next witness be?
Mr. Lumpkin.
All right. Can we bring him up or in?
Hey, Judge, if I could switch, well, never mind.
I'm
If
sorry.
it's not too late, I'd rather let me call Mr. Rodriguez.
I think Mr. Lumpkin is there.
If he's already here, then he's already here. Great.
Who
Okay.
do you want? Who do you prefer, Mr.
Lumpkin's fine.
Durham? I didn't hear you.
Mr. Lumpkin will be fine.
Good. There he is.
Good day, sir.
Can you swear him properly?
No, ma'am, we cannot.
Then I'll do it.
Well, you can't, Judge. He's muted.
Well, he can say.
Okay, there we go. I can do it. Yeah.
Now I'm ready.
All right, Mr. Lumpkin, you do solemnly swear or affirm the evidence you shall give in the matter pending shall be the truth, the whole truth, and nothing but the truth, so help you God. Do you so
I do.
swear? Thank you. Mr. Durham, conduct your examination, please.
All right. Mr. Lumpkin, how are you today?
I'm doing well.
And tell your name for the record, please.
I am T. Brian Lumpkin.
What do you do for a living?
I'm an attorney in the state of Georgia. I've been licensed since 1995. I do criminal defense practice nearly 100%.
And did you do anything before you started criminal defense?
I was a prosecutor for the state of Georgia as an assistant DA for 10 and a half years.
And where's your office at?
My office is currently on Lawrence Street, just down from the courthouse here in Marietta, Cobb County, Georgia.
And is that where your practice primarily is based?
That's correct. And on cases
Now,
throughout the metro area.
okay. Have you had an occasion in this to represent Ross Harris in this case?
Absolutely.
All right. Well, tell us, when did you come on in the case?
I don't recall specifically the date of it. It was well after Ross had been arrested and the investigation had been going on for some time. I want to say maybe even a year afterwards that Mr. Kilgore had approached me about possibly being of assistance in the case.
Okay. And did you have meetings and talk about the case when you came on?
We did.
What was y'all's theory or strategies about how the best route to defend Ross Harris against these charges?
So primarily, of course, we were focused on showing that there was no intention by Mr. Harris to have committed any sort of harm or danger to his child. He loved his child and had been a good father for the entirety of the child's life. And that was our primary focus as we began getting information from the state, looking at what they were saying and what they were doing. it became apparent that we were also going to need to show that there was a lack of credibility in their investigation as to what they were putting out and how they were going about getting information in the case.
What do you mean about lack of credibility?
Well, of course, the front end of this case, what, in my mind at least, gave it so much attention were statements made about Mr. Harris alleging that he had researched how to kill a child or researched hot car deaths or had made some sort of plans or internet searches about that. And as we looked at the evidence, we found out that was completely untrue. But that narrative had been put out there for quite some time. And as we learned, had been testified to under oath that it was true, along with several other things. And it became clear to us that they were moving forward trying to satisfy what their theory was without regards for some of the truth of what had actually happened.
All right, when you say you're going after their credibility, I just wanted you to define the credibility for me.
Sure. So whether or not jurors would be able to trust what certified law enforcement officers would testify to, whether or not they could trust the suggestions that were being made, ultimately, could they buy into a theory that the state might offer into the case to try to suggest that this was anything other than an accident.
Now, and so let's go on as far as what your roles were.
Okay. So we separated the case into different parts because it's quite voluminous, as you well know, certainly. My role generally was going to be dealing with the evidence collection and seizure searches and seizures of evidence in the case. I would have some other minimal roles as they became necessary with individual witnesses. But for the most part, I was dealing with the from the crime scene forward as to how evidence was gathered, maintained, and handled.
Okay. Now, and you mentioned that you were in charge of the search and seizure portions.
Correct.
Okay, so there was a lengthy hearings on the search warrants. Were you in charge of those?
Well, certainly, I was the attorney responsible for presenting our motion and the evidence to the court.
Okay. And how did you go about doing that?
So we prepared the motion, of course, and the state has a burden of proof to justify what they've done. So as they called officers that were involved in the obtaining of evidence from a cell phone to computers to the scene itself, and then subsequent searches of all those. Obviously, in this case, the searching of cell phones and computer evidence, forensic evidence of a digital nature was very important. And so I was tasked to look at each one of these search warrants, identify specific things in them that were at issue legally. In the motion express, of course, we're looking at whether or not there's probable cause in the warrant, whether or not there's been misleading done to the magistrate in creating the warrant, whether or not the execution of the warrant has been done properly, and whether or not they've exceeded any other constitutional bounds in the process of obtaining and or executing the warrants.
Now, and you mentioned any misleading done. Did you find that to be an issue?
Absolutely. It was incredible in my mind how often, I think there were 10 search warrants were obtained with statements in them that were completely not based in the evidence. That was bothersome to me, to say the least. They then changed some language at some point, and then I think got another 12, 18 other warrants that still had some misleading in them as far as I was concerned. And felt like that was an important issue to address for the court to be aware, to see if the would be concerning enough to the court that they were willing to lie to a magistrate in order to get evidence they otherwise might be entitled to.
Is that part of the basis for why trying to go after the validity of the search warrants? You had the motion hearings?
Absolutely, absolutely.
And ultimately, were your motions to suppress the search warrants denied?
They were denied.
All right, so then you start getting ready for the trial.
Right.
Let's talk about that then. As far as the trial, what aspects, how did y'all divide that up?
So we were still in pretty much the same separation of duties, following on those same general areas as far as the type of witnesses would be called. Simply because we were already familiar with the information firsthand. Mr. Rodriguez was handling most of the computer forensic information. I was handling a lot of the law enforcement evidence part, apart from the lead detective, and Mr. Kilgore was handling the majority of the bulk of the rest of it.
Okay. And what, as far as your duties is in the trial, when it came to, did there come a point that you tried to call Detective Murphy?
We did, absolutely.
Tell me about that.
So we were put in a position to call Detective Murphy in our case in chief, because as we were trying the case, the state was putting on its case, we had gotten to the point of addressing some of this misinformation that had been given out by the police, and in attempts to question the lead detective about it. The state objected and claimed it was hearsay, that he wasn't the one who had gotten any of these search warrants, and that we needed to call that witness. And my review of the transcript, I see I wasn't part of the bench conference where it was said, but the transcript bears out that they were informed, okay, then we'll call the detective. If you're not going to call the second in command of this entire investigation, then we'll certainly call him and we'll address it. And that seemed to satisfy everybody.
Stop it there. Let me just stop a second. If when they had that bench conference, that was the end of Detective Stoddard's testimony.
That's correct.
And so if I'm hearing what you just said, you were trying to get the information out through Detective Stoddard.
That's right. Mr. Kilgore was questioning him, and as I recall, he had led into a question that was going to specifically ask about information provided in sworn testimony in the previous book to the magistrate.
Now, were you part of the? I mean, were you aware of what the basis that the defense team was trying to get that information in through Detective Stoddard? What was the purpose of it?
Absolutely. So we were trying to show. We're trying to let the jury see actual evidence of the lack of credibility that we saw in this investigation. We wanted them to be able to address the biased motive that we believe that the state had created in this case, how they were supporting that by obtaining of evidence to the point of misstating evidence to a magistrate judge under oath. So we wanted to bring that out.
All right. And did the validity of the search warrants play any part into that when you were trying to, when the defense team was trying to cross-examine Detective Stoddard?
The validity of the search warrant certainly was not an issue anymore. The court had ruled on that, and we couldn't go into that.
And had you preserved those issues for appeal when we needed it?
Absolutely. I feel like we preserved it every way we possibly could.
Okay. Now, so you called Detective Murphy. What happened?
So as we called Detective Murphy, I think even prior to us physically calling him, the state filed a motion in limine, either the Friday before that Monday or the day, I forget exactly which day it was, but basically suggesting that we shouldn't even be able to call a witness, that we'd all at least discussed that was going to happen some days before. We addressed that. They indicated that they were worried about hearsay being obtained from Detective Murphy. I addressed the court with regards to that we were not trying to obtain any hearsay. We were simply trying to put in the actual statements of the investigation that included the statements made under oath by Detective Murphy in order to try to figure it out. Where did that information come from? Why was that created? who created it, and why was it told to a magistrate when the evidence did not bear it out. We weren't, the judge granted the motion. As I recall, I was a little bit unclear of exactly what the court was going to let us do or not do. Ultimately, we called Detective Murphy, proceeded to ask him some questions, and any time that I attempted to address this very issue of the credibility of the investigation, state objected and the court sustained it. Ultimately, we placed a proffer on the record as to what it was we were trying to get out in front of the jury, and our purpose for doing that to defend Mr. Harris and show the lack of credibility of the investigation and attack the motive that they had created.
And you've also given the reason why you wanted to do that today before us as well.
That's right.
Now, did you, so in the proffer you made was before the court, and you were allowed to cross-examine, or excuse me, to question Detective Murphy about a few issues. Is that right?
That's correct.
Did it touch on any of the issues that you had really gotten in there for?
He did not allow us to address what probably was our priority for calling him. Certainly wanted to bring out some incidental other facts as well, which included the light bulbs that had been purchased, that wasn't some made up excuse to get light bulbs, but in fact the house needed them. And he took part in searching that to find that out. Regarding the things he had said about his observations of the car seat and straps where they were placed in the car seat.
I'm sorry, I think you're finished. Had y'all planned to call Detective Murphy in your case in chief before y'all were denied an opportunity to cross-examine Detective Stoddard?
No, he was not under subpoena or anything until that bench conference was had in the midst of Detective Stoddard's testimony.
All right, so he wasn't planned to be testified until at that point. Is that right? Is that what I heard?
That's my recollection, absolutely.
Thank you for your time, sir.
Yes, sir.
Thank you.
May I proceed, Your Honor?
Yes.
Thank you. Can you hear me okay, Mr. Lumpkin?
I can. I'm hearing a little bit of background noise, but I think I can pick your voice out. Thank you, Ms. Denikoski.
I'm trying to see if it may be coming from Macon State, but we'll proceed. So the state did not call Detective Sean Murphy in its case in chief.
That's correct.
Right. The state did call Detective Stoddard in its case in chief.
That's correct.
And Mr. Kilgore is the one who did the direct examination of Detective Stoddard. Is that correct?
That's correct.
All right. And Detective Stoddard is not the one who took out the search warrants for the cell phones and computers involved in this case. Is that correct?
He certainly did not take out the initial ones. I believe he did take out some of these search warrants, but I can't recall specifically what they were for.
Okay. And at the 3-day-long motion to suppress the search warrants, you handled that.
I did.
And Detective Murphy was on the stand for that. Is that correct?
He was, amongst others.
Okay. And regarding this entire case, the strategy here, as I think you've said, is to attack the state's hypothesis that the motive behind Mr. Harris killing his child, and that this motive somehow was created by the state. Is that right?
In addition to the primary theory, of course, that this was completely an accident, not intentional. Absolutely, we were trying to show that the theory that they had created did not fit the evidence of the facts in any rational way.
And do you feel that you were able to do that, get that out in front of the jury?
No, we weren't allowed to put up the evidence which bore that out, at least in my part, as to Detective Murphy.
Okay, so I that was me badly phrased. Overall, were you able to Was Mr. Kilgore able to attack the credibility of Detective Stoddard through his cross-examination?
I think Mr. Kilgore certainly did attack the credibility of Detective Stoddard and was able to get him to, at least to some extent, admit to some false statement he had given previously.
Okay. So generally, overall, your primary strategy was this was an accident, no intent by Mr. Harris. Is that correct?
Correct.
And then the second strategy was to attack the credibility of the law enforcement officers in order to undermine the motive evidence that the state was presenting.
Yeah, that's correct. But to be clear, it's not as though one was lesser than the other. And it's my wording. I think I said secondarily. They were working hand in hand, right? To the extent that we believe that evidence was clear, he did not intentionally do this in order to combat how the state was trying to show otherwise. It was the lack of credibility of the investigation that they were using to do that. So we were trying to highlight how that had happened.
Okay. So overall, with both of these strategies, have you used those before in trial as a criminal defense attorney?
Absolutely.
Okay. And they're effective strategies, aren't they?
I have found them to be effective at times.
Okay. And was it your strategy, and did you actually follow through, with the exception of what we're talking about, Sean Murphy, the rest of the trial? Were you able to cross-examine Detective Grimstead and Detective Stoddard and the other GBI agents who testified at this case, in this case?
As you noted, I didn't handle the examination, but no, we were not allowed to cross-examine Detective Stoddard about these very same issues. The state objected that it was hearsay. As to Detective Grimstead, absolutely, we were able to cross-examine him quite a bit. I don't recall him doing or saying anything that was false. In fact, it was his accurate keeping of information that allowed us to show how this, frankly, the state thereafter had created a scene that did not ever exist. I don't recall if there was another witness you indicated that we wanted to address. Obviously, Detective Murphy didn't get to address it at all.
Okay. And the light bulb issue, just as an example, that was brought out during the state's case in chief, correct?
I don't recall that it was specifically. I think there were some photographs of light bulbs. And when you say the light bulb issue, we may be talking about two different things. I'm referring to the fact that the home, the residence, the Harris residence, had some light bulbs that needed replacing in a bathroom, as I recall. And Mr. Harris had bought bathroom bulbs that matched those exactly on the day of this incident. And so to the extent that we were trying to show that it wasn't some made up reason to get light bulbs just so he could go to his car and check on how things were going, as was suggested by the state and refuted by the evidence, in my opinion, there was an actual need for the bulbs, and he got them and he placed them in the car without ever getting inside the car.
And that was presented at trial, correct?
That was presented at trial through Detective Murphy. I don't recall, I think the original question, I don't think anybody else had testified to that specific extent about seeing the bulbs and matching them up.
All right. And in your extensive experience as both a prosecutor and a criminal defense attorney, have you ever had the occasion where a judge has made a ruling that's affected your next decision or your ongoing trial strategy?
Absolutely.
I'll pass the witness.
A couple of quick questions, Mr. Lumpkin. Primarily, let's go to the last question that was asked to you was basically, has a judge ever overruled you or kept you from presenting anything? Is that right?
That's how I understood the question, and my answer, of correspond to that. Absolutely.
Well, in this case, was the false information that y'all found that had been provided to the magistrates, and you said how many times?
There were at least 10 warrants initially involved in the case within the first couple of days of the investigation, I recall. And thereafter, I believe there were between 12 more and 8 or 18 more, I forget. Certainly well over two dozen warrants were secured.
Okay. And they all, in all varied in degree, but your contention is they provided false testimony.
That's correct.
Okay. And was that an important part of your defense theory?
I certainly believe it was very important.
Okay. Why? What were you trying to show?
Sure. So we were trying to show the extent to which law enforcement was willing to, we're trying to show the lack of credibility that they had by showing actual evidence of the extent to which they would go to mislead, mischaracterize, or outright lie under oath to a judge. If they were willing to do that, then certainly they're coming to testify in this trial. It would hardly be a stretch for them to mislead, mischaracterize, or lie to the jury. So we wanted to show.
Did you think they were being even-handed or in their pursuit of this case?
Absolutely not. I think everything was biased in their mind at whatever point they made the decisions, and it continued to get worse as I saw it.
Did you have a theory as to why they were biased?
Well, I don't know if I couch in terms of theory. I certainly had a belief that they had made an arrest of Ross Harris before they got all the information, and they would not relent. And they decided they got information about him. They didn't like him, and so they decided to find evidence, whatever they could find, to support that he was just a horrible guy, rather than look at what was really happening with his child. And thought the evidence bore out very clearly that there was not an inch of evidence he had any malice or dislike for his child. He loved his child. Okay. And to do something of this nature was beyond understanding, and certainly without any evidence to support it.
Okay. Thanks.
Yes, sir.
Wait. Judge, hold on 1 second. Thank you very much.
Yes, sir.
Nothing further from the state.
Mr. Durham, do you have another witness?
I have Carlos Rodriguez, Your Honor.
May I remain and listen to the rest of the testimony? If I remove my video, will that be okay?
Is there any objection by either party? Okay, you may do so.
Thank you, Your Honor.
There's Mr. Rodriguez. Mr. Rodriguez, raise your right hand. You do solemnly swear or affirm that as you should give in the matter pending shall be the truth, the whole truth, and nothing but the truth, so help you God. Do you so swear?
Swear.
Proceed, Mr. Durham.
Tell us your name, please.
Good morning. My name is Carlos Rodriguez.
And Mr. Rodriguez, where do you work?
I'm an attorney here in Marietta. I have a small law firm, criminal defense firm, Kilgore and Rodriguez.
And what areas of law do you practice?
Criminal defense.
You said you was Kilgore and Rodriguez. Would that be Max Kilgore?
That's right. The lead attorney in this case.
And how long have you been in practice?
since 2010, 10 years.
Now, and how much have you practiced? Have you been primarily in private practice your entire career?
Yes.
So, in this case, did you have, how long have you been with Maddox Kilgore?
I believe we started our firm in the summer of 2014.
Okay, and so did you become part of the team that helped defend Ross Harris in this case?
Yes, sir.
Okay, so tell me about what y'all started as far as, did you start in it initially or did you come in later on?
No, from the very beginning, I was involved.
So did you have meetings and discuss strategies and ideas and the best way to attack the case and to defend Mr. Harris?
Yes, formal meetings, informal. I mean, we practice in the same building, so we probably talked about this case every day.
Okay. So what was your defense theory or theories?
Well, it was, I guess, a two-pronged defense. One, that it was an accident, that Ross did not intentionally leave Cooper in the car, that he was a loving father, that he wasn't, he wouldn't have done this intentionally, that this was a memory failure, and that there was a rush to judgment by law enforcement and the prosecution to think otherwise. And so there's the accident component, really a legal defense, but then a factual defense where it was exposing the bias of the investigation from the state and prosecution from the state.
And did y'all split up duties in the case?
Yes.
Okay. What were you assigned to do?
Well, I mean, I guess under the general umbrella of electronic evidence, my responsibility was to try and lay eyes on everything in this case. Every piece of evidence that was obtained from Ross's computers, from Ross's cell phones, from email accounts, social media accounts. I mean, anything that was electronic, surveillance videos. I mean, and I was responsible for specific witnesses in the case. I can't recall or list them right now.
Okay. I just so basically you were the computer geek.
Yeah, for lack of a better word, although I don't think I'm a computer geek, but
okay. Well,
I was pretending to be.
Did you have occasion to be in charge of the evidence as far as Mr. Persinger for the state's expert computer?
Yes, I was the state's private computer expert. In addition to the detectives with Cobb County Police High Tech Crimes, I was responsible for all of those witnesses.
All right. Talk to me a little bit about Mr. Persinger now. When you were preparing for his testimony, did you receive anything in regards to his testimony?
So I specifically can recall him creating a report from I think it was PM Investigations was the name of his company. Obviously, and I don't have his file, but the way that we would organize the preparation of witnesses is we would have really everything from discovery that had to do with that witness, we would have them in a folder. And so I know that I would have had Mr. Persinger's report that he created, any police reports in discovery that would have mentioned him, any items of evidence that I anticipated that he would have testified about. And I believe that there may have been some handwritten notes, detectives' notes that were provided in discovery about Mr. Persinger. I think generally those are the things that the state provided to us about Persinger. Go ahead.
Okay, let's talk about his report. What did he gave a report of what he was assigned to testify to?
Yes.
Tell me about that.
So it was basically two things. The whisper image. Do I need to explain to you what the whisper image is, or are we past that?
No, we're not past that, but go ahead. You said there's two things. Give me the two things. And then
okay, the whisper image and this video on YouTube that was a veterinarian doing a demonstration about how hot it gets in a car and reminding folks not to leave their pets in the car when they, go shopping.
So it was like a public service announcement, or is that what y'all were calling it during the trial?
Yes, sir.
Okay. Just briefly tell us what that whisper image was.
So Whisper is an application. It's a social media application where a user can post a image or a photograph, and it can be like a stock photograph provided by the application, and the user assigns text to the picture. So like if I were a user on Whisper, and it's supposed to be anonymous. So if I was a user on Whisper, I could type, I'm testifying in court today, and the application might generate a photo of a courtroom, and then it puts it out there for the Whisper world, all users that have that application to see. And then there's a component that allows Whisper users to chat and communicate based on or comment on the images. And so in this case, Mr. Persinger was, as best I could tell, he was tasked to look into the Whisper image and find out as much as he could about it. And ultimately there was a Whisper image that was not posted by or created by Ross. Ross commented or—
Let me stop you just for a second. When you used the phrase whisper image, was the task for a specific whisper image?
Yeah, specific whisper image. It was someone had said something to the effect of, "I hate being married with kids," and it was. I remember it being a big, bright red image. I think the state blew it up. I mean, had a large reproduction of it, like on poster board.
All right, and was that a trial or the probable cause hearing or both or what?
I can't recall if it was at probable cause. I think it was testified to on probable cause, but as far as having the big blow up of it, that was at trial.
Okay, and it was something along the lines of, "I hate being married with kids." Did that ever get attributed to Ross Harris posting that?
Ever at trial?
We say never at trial. Did it ever get attributed?
No, I'm asking for clarification. Like ever?
Oh, okay. Well, then was at any time?
Oh yeah. I mean, there were detectives' notes that suggested that they were 80% sure that Ross had created and posted the Whisper image. That Whisper image, the one about hating being married with kids. And certainly at the probable cause hearing, it was suggested that he was the creator of that post, and it was part and parcel with the state's theory that he wanted to live a child-free life, and that was the purported motivation to kill his son, was to rid himself of his marriage and being a dad.
Now, did as time went on, with all the electronic and technology and social media communications, did things become clearer about what information was or the sources of it?
Clearer for us or clearer for the state?
Well, I mean, clear for y'all. What clear for anybody, any objective person? How's that? Did you get more information as the case went along to find out? Okay. All right.
Well, it was clear to us. I mean, very early on, as soon as we heard that it wasn't Ross. I mean, Ross only had one child. It obviously became clear to Cobb County Police and state sometime after the probable cause hearing.
But as the case goes on, this case progressed, and more things were discovered through the search warrants, through whatever information you could get to go through the technology, and you could tie into who sent what on these social media things. Am I correct in that?
So can you ask that? Can you ask that again? I'm sorry.
Sure. What I'm trying to find out is, there's been testimony that this was ongoing discovery. A lot of things were coming out, and things were there was information that you would have early, but you needed to check into it later on, and investigations had to be done on the sources of those information.
Right.
Okay. Is that true?
Yes.
And is this whisper image something like that it became apparent more later on as the case went on and more investigation went in as to where the source came from?
I would say that's true, but it certainly would have been prior to attempting to try the case in Cobb County. It was definitely before that, because Mr. Persinger had turned over that report prior to the first attempt to try the case in Cobb.
Okay. And you mentioned that I hate being married with kids, that paraphrasing of that whisper image. Was that found to definitely not be sent by Justin Ross Harris?
Oh, definitely. Yeah, it was definitely not him.
Okay. And all right. So, and that was one of the tasks that Mr. Persinger did. Was Ross ever attributed to a follow-up to that comment?
Yes. He commented on it. Ross had responded to that image, or responded to the person that wrote it and created it.
Do you remember what that response was?
It was a series of responses. I think it was a kind of a back and forth, but Ross was encouraging. He certainly did not suggest that he hated being married or he hated having a child. In fact, I think what he specifically said was that he loved his son. But suggested, sometimes we all need escapes, or, we all need a break or something like that.
That was, that statement was attributed to Ross.
Yeah, Ross wrote that. Yeah.
All right. So now let's go into the next thing that under his report that Persinger was tasked to do, and that was the PSA video.
Right.
What was the task there?
I mean, I don't know really, because, Ross admitted in his interview to having viewed it. I think perhaps Persinger, at least by my memory of the report, he just confirmed that it was, there was history on Ross's computer of having accessed that video.
All right. Was there some concern early on about searches or research being done by Ross Harris for videos of deaths in cars?
Yes.
Okay. And was this vet video, the PSA, was that part of that initial concern?
Yes. So I believe what was originally testified to in the probable cause hearing, alluded to in pretrial hearings, sworn to in search warrants, was that Ross stated that he had researched how long it took for a child to die in a car and the temperature necessary for that to happen. And I mean, obviously, after reviewing the evidence and doing our own investigation into all the electronic evidence and his interview, not only did Ross not say that, but he didn't do those things. He did not research or search for how long it takes for a child to die in a car. And he wasn't actively researching hot cars or children dying in cars or children dying or anything of the sort. It was basically a video that just popped up on his feed or that he was redirected to after some post on Reddit.
So those were the two items that Mr. Persinger was tasked with, according to his report.
Yes, yeah, very basic.
Okay, and what did he testify to anything other than that?
Oh yeah. So the whisper image and the vet video was merely, in my mind, a fraction of what his testimony was really about. He gave this demonstration based on a series of like screenshots or captures of Ross's Google Chrome preferences, and he gave this demonstration about changes in Ross's internet preferences. And he talked about a particular website of www.griffinpsychology.com. And that this was a website that Ross had essentially indicated or designated as a favorite in his internet preferences, that it was a website that he somehow had control over, that he was able to change that website. But that Mr. Persinger had gone to that website himself in preparation for his testimony and had seen that it was a psychologist that was, I guess, advertising or describing some of the services that he provided, which was involved with the criminal justice system, like jury selection or something like that.
And did it come out later in his testimony that Ross Harris actually was a website developer for Griffin Psychology?
So I wasn't a part of the conversation, but apparently during a lunch break, Jesse Evans, the ADA responsible for his direct examination, had brought it to Mr. Persinger's attention.
So was there any before the lunch break, what was the tone of the evidence toward Griffin Psychology?
Oh, it was, so Mr. Persinger had like stepped up off the stand. They had it blown up on the big Mondo board, which was this big, it was basically a big television, interactive television where you can plug in devices, flash drives, and you could plug in exhibits and blow it up real big for the jury to see, and you can manipulate it like a touch screen, zoom in on things. And I mean, a really neat tool for advocacy and putting on your case. And he put on this show, this demonstration about Griffin Psychology, and that it essentially painting this this picture that it was very suspicious for Ross to have been visiting this website, and that's certainly how I took the point being made, which was, and I think Mr. Persinger even said that this internet behavior was indicated someone that's like a Dr. Jekyll or a Mr. Hyde during this part of his testimony.
Okay, and so that was before the lunch break.
Before the lunch break.
And then after the lunch break, you said the tone. What came out after lunch break?
I mean, in regards to Griffin Psychology, it was that, Mr. Evans had brought to Mr. Persinger's attention that Ross Harris was actually doing some website work for Dr. Michael Griffin, and basically that Mr. Persinger knew nothing about that, and the state wanted to leave it at that. Just that, he didn't know anything about that. But
Did it come out when the Griffin psychology information had been uncovered by Mr. Persinger?
so he testified that he had only learned about the griffinpsychology.com web preference like 3 or 4 days before his testimony, and that's the reason why it wasn't included in his original report from, I don't know, 7 months prior, and that the screenshots, well, they tried to suggest that the only value or the only importance in referencing Griffin psychology was just to show that it was in his web preferences. But obviously that wasn't the purpose of the demonstration, and that wasn't the purpose of him describing why or what is all on the website and what Dr. Michael Griffin does.
Now, did other information come out during his testimony that was not on that report?
Yes. So he testified about looking into a search about how to survive in prison, which Ross never searched. There was testimony about some information, some web history about a Sandals resort, testimony about
What would the Sandals resort? Why would that be something that would be brought up during the trial?
Oh, because they wanted to suggest that Ross was planning some trip without Leanna and his child. Because apparently Mr. Persinger had found some data on the computer where
let's see. Was there anything regarding real estate or anything like that?
I don't think that he offered any direct testimony about real estate. I don't think so. I know that he talked about the clearing of his cache. That's one big topic that they honed in on, is that Ross had cleared his cache, which is the temporary internet files on his Google Chrome browser, but he didn't do that on some other browser. And that was indicative of someone that's a Dr. Jekyll, Mr. Hyde, that he's doing, it was all this show that was not in his report.
Okay. Explain to us who aren't quite as technologically gifted as you are about clearing your cache.
Okay. So your browser or your computer will store temporary internet files or temporary internet information about a website that the website automatically pushes to your computer, sends to your computer when you visit that website. Okay. The reason that a website does that is so if you visit that same website in the future, it'll be a lot faster to load the page and all the information on the page, because small temporary internet files about that website have already been saved on your computer. So it's not something that the user actively downloads from the website. Okay. If you clear your internet cache, then you are removing that information that the website has automatically pushed to your computer. And so your browser has to load the information on that website all over again from scratch. Okay.
So how many browsers did were attributed to Ross Harris?
I know that he used Safari. I know that he used Google Chrome. I know that he used Mozilla Firefox.
Okay, let me just, there were two, what were being concentrated on in Mr. Persinger's testimony?
So Mr. Persinger was he was trying to juxtapose the activity on the Mozilla Firefox against the web history and internet cache on the Google Chrome, two different browsers.
Okay. And did he make any comments about the comparison between those two?
Yeah, he said that it was suspicious. It was highly suspicious and indicative of someone that's trying to hide something.
Okay, now, and this came out during his testimony, and it was not provided to you beforehand?
Yeah, that opinion was nowhere in his report.
Okay. What about the other things we talked about earlier as far as the how to survive in prison and the Sandals vacation thing?
Yeah, nowhere in his report.
So, and Griffin psychology wasn't in his report?
No.
Okay. All right. Now, in your defense of Ross Harris, what did you try to do?
Well, I mean, so originally my plan was to confront Jim Persinger with the fact that all he was tasked to do was look into the Whisper post, which we know that Ross was not the creator of the, I hate being married with kids post, and the vet video. And he really offered no further assistance, at least based on his report, no further assistance to the state. That's been my plan. That had been kind of my line of attack. But when all of this came out for the very first time on Direct about the Griffin psychology, it was clear to me that Mr. Persinger either did not know that Ross was working as a web developer and starting a new business where Michael Griffin was a client and he was working on his website, or they were hoping that I didn't know and we're going to try and pull a fast one. And so at that moment, we kind of pivoted, or I kind of pivoted, and my plan was to confront Jim Persinger with all of the data that would have been obvious to him as a computer forensics expert. And he testified multiple times about digging deeper, okay, about being thorough in his investigation. So having held himself out as this thorough investigator, someone that trains law enforcement and provides support for Cobb County high-tech crimes, I wanted to confront him with all the easily available, easily discoverable information in emails and chats that would have made clear to him that he was not involved with Griffin psychology in some sort of nefarious plan or conniving plan to prepare for a criminal trial, but that all of that information really would have exposed how biased his investigation was, biased in favor of the state, not really a modest attempt to search for the truth, but just cobbling together the state's theory that everything that Ross did on his computer is suspicious, that everything he did must be because of some motivation to live a child-free life, which obviously wasn't the case.
All right, so you said that you wanted to go get information that's easily discoverable and attainable for somebody. Did you get that information?
Yes, it was already in evidence.
Okay. it was already in evidence, so the state had it as well.
Absolutely. I mean, the state had used Google Chats that demonstrated this very thing with witnesses earlier in their case in chief. Emails they had used earlier in their case in chief.
Now, in regards to the Sandals vacation,
Right.
what did you find?
Well, that in fact Ross had been planning on going on a family vacation with I think his brother and sister-in-law and Leanna and Ross's parents, and it was a cruise, and there were all kinds of emails with a travel agent. And I can also recall that there were some discussions between he and Leanna about wanting to go on a trip together without Cooper, just to have kind of like a trip for the two of them. And had Mr. Persinger actually done a deep investigation, that would have easily been available to him and easily recognizable as something that defeats this suggestion that they were trying to make. And so I wanted to, in front of the jury, show that bias in his investigation.
Did you attempt to do that?
So with the specific vacation emails, I did not, because my first attempt was going to be to show and confront him with the emails and chats about Griffin's psychology.
Okay.
But when the state objected to basically the use of any emails and chats, because they made clear on direct, he doesn't know anything about it. And so they wanted to leave it at that. He doesn't know anything about it. And so there's no foundation. He can't testify to it, even though he's an expert and actually mentioned these things.
Let me go ahead then. You mentioned the what is prison really like? Was any emails or any information that you looked to try to confront him on that?
Yeah. So, I mean, I tried to ask questions about it, but what I wanted to be able to show were that there were Google chats, very easy to see, very easy to ask, very easy to acquire, where around the same time as the search that Ross actually made, which was what is prison really like, he was watching the show on Netflix, Orange is the New Black, which was a show about a women's prison. Okay. And so the timing was very clear, and Mr. Persinger testified about cross-referencing evidence that he found with other sources of information. Okay, so this would have definitely undermined his credibility and opinion that as a computer forensics expert, he was digging deeper and performing a thorough investigation into Ross's digital history.
And is that the same thing, the same basis you were going after the information regarding Griffin's psychology?
Yeah, absolutely. And it's the same source of information. It was the Google chats and Google emails.
And was there any discussion about, you mentioned the deleting his cache, anything that you wanted to, any information, emails or anything you wanted to confront him with regarding that issue?
I'm sorry, say that again. What issue?
You mentioned earlier about, deleting his cache or whatever the phrase was.
Oh, right. So there were Google chats between Ross and two of his friends that were starting this new business, where they're talking about testing the website. And he's asking people, hey, go look at the website, test it, see if they're having any issues. And there were even emails between Ross and Dr. Michael Griffin where he's talking about, I've mobile tested it and I've tested it on different browsers. And so it would have been clear to Mr. Persinger that had he read this email, seen this email, not only is he a web developer for Dr. Michael Griffin, but he's explaining to Dr. Michael Griffin that he is testing the functionality of the website on different browsers.
Okay.
Mr. Persinger said he was a web developer. That should mean that there isn't a suspicious, nefarious reason for him to be interacting with griffinpsychology.com.
Okay. And now, what steps did you take to try to confront the witness?
So I definitely asked questions about it, but I wanted to be able to actually impeach the witness with the state's evidence. And so I tried to do that.
How did you try to do that?
So I tried to tender them as defense exhibits, the select portions of chats and emails. That was objected to. And then I tried.
Let me stop you for a second. When you say that was objected, I just want to be clear on the record.
Yeah.
How did you do that? Did you put them on discs themselves, thumb drives or something?
No, I believe I printed them.
Oh, okay.
I believe I printed them out because what was in evidence was this, huge, voluminous response from Google of all the chats that they had available, all the emails associated with his account. And so I couldn't.
That would be state's exhibit.
That was the state's exhibit. I don't remember.
What, do you remember the number? Was it 601?
Hold on. Ms. Demikowski gave me her response, and I think it's in there. Her response to the motion for new trial.
Would it have been 601, exhibit 601?
That sounds right.
Okay. All right. Well, the exhibit, you went to that exhibit and got hard copies.
Yes, state's exhibit 601.
And you got hard copies of it, and you attempted to it, and they would not allow that.
The state objected to it, the judge wouldn't allow it.
Okay. And then, did you take the next step? Well, hold it. Why was it not allowed in at that time?
Well, wait. So when I printed them out, 601 was already in evidence. When I printed them out, I marked them individually as separate defense exhibits.
The hard copies of the email.
The hard copies, correct. And so when the objection, if I can recall, was lack of foundation. And the defense exhibits that I had printed out and was prepared to start impeaching Persinger with were merely singled out printouts of what was the larger piece of 601.
And that didn't work. What'd you do next?
So that didn't work. And so my thought was, let me use 601 because there's no foundational objection to that because it's already in evidence. I didn't think that there was really a legitimate foundational exception to the others because they were already in evidence. But I tried to use what was already in the state's evidence. Yeah.
And that was objected to, and you were not allowed to go further with that.
Right. My belief was this was evidence or materials that I could impeach the witness with that drew his opinion and drew his credibility in question.
All right. Now, I think. One last thing as far as that go, how did you go about, was it the difficult task for you to get those specific emails out of 601?
So, no, but I do recall having to have our computer forensics expert, Scott Moulton, he had to extract that data and convert it to PDF. Once he did that for us, it was very easy to search. Literally you could search within your computer, like for the word orange, and it would direct you within the Google Chats to any place where the word orange had been used, and it was real easy to find it, or prison, or any word.
Okay.
Griffin psychology.
All right. During your preparation of the case, did you find out if the state, when they tasked Mr. Persinger for those two initial tasks, when he was assigned for those two initial tasks, were you able to find what information he was provided by the state?
So, from what I recall, he was given the full extraction of Ross's Apple MacBook and his work work computer, a Lenovo, as well as an iPhone 5. So he was given a data dump, everything on those devices.
During his testimony, did he indicate he went back and got anything else during his digging deeper?
Yeah, I recall him, an example of him asking for Cobb County High Tech Crimes to provide him with more information about something.
Okay. All right. Now let's step on over. Did you have an occasion to handle the portion of the trial regarding the 3D scanning?
Yes.
Okay. Did at the start of before the trial back in April or so, were there any motion hearings regarding the 3D scanning?
Yeah, Maddox handled those. Maddox Kilgore did.
And the objections were made. Do you recall that?
Yes.
And do you recall whether they were granted or denied?
Our motion was denied.
Okay, so the state was allowed to go forward with the scanning back in April or so.
Right.
Okay, at that point, Maddox was in control of the 3D scannings.
I wouldn't say in control. I just don't remember why, but he handled that pretrial motion for whatever reason.
Okay, so he did the motion hearing. Now at trial, you handled it.
At trial, I handled it.
All right, what happened? Can you just give us a brief summary of what anything unusual happened?
So the car seat inside of Ross's SUV, it had been removed from the car and put back in, but it was put back in a way that was not the way that the car seat was originally in Ross's car. Okay. When the 3D scans were done, David Dustin came in and he didn't stage the scene for the scans. Either Phil Stoddard or other detectives with Cobb County, they did, and I guess maybe the DA's office was involved. I can't remember, but other people other than David Dustin staged the scene for the scanning, and then David Dustin scanned it. In the middle of trial, it came out that the way that the state had staged the scene was not accurate. And so they had to bring David Dustin back to Brunswick, or I say back, I don't know if he was there to begin with, but they had to bring him down so that they could stage the car and the car seat inside of the car so that David Dustin could scan it again.
And you handled the testimony on that?
I handled the testimony. And he also scanned the car and the parking lots and created, he created some demonstrations, some animations of those scans that were shown to the jury. But as far as something unusual. I mean, what jumps out at me was the having to rescan the car and the car seat.
And when were y'all provided information? When did you first learn about the new scan?
I guess when the state told us that there was a new scan done in the middle of trial.
So it was the middle of the trial you found out about it?
Yeah. I can't remember how far along we were. I mean, it was, if it wasn't a month, it was close to a month after we started picking a jury.
Okay.
After we had moved down there.
And after hearing making your objections and other things in hearings, was the state allowed to introduce that the 3D scans and the animation into trial?
The new ones, yes.
Okay.
Well, and the old ones actually. I think all the scans were introduced.
Okay. And so you handled this. What does it look like in court as far as how is the scan put up there, the 3D scan? I mean, how is the jury seeing that? How's it presented in court?
It kind of looks like a cartoon. I mean, it's three-dimensional. You know, it almost looks like a video game. It's really the best way that I can explain it. It kind of there's a feature that Mr. Dustin was able to do, which is called like a fly-through or a flyover video, where it kind of gives you a bird's eye view.
Okay, hang on.
Go ahead.
We'll get there, but where do they put it? I mean, is it on a small television? Is it on a projector? How is it shown to the jury?
On the Mondo board, on the that huge monitor that's interactive. You can hook a computer up to it. It's basically like a huge projector.
Okay, but a huge screen, I guess.
Yeah.
Okay. All right. So now, when he's presenting that, you mentioned you were talking something about a flyover. What is that?
This was something that he created. It's an animation that showed, I think what was played for the jury was an animation that showed Ross's SUV where he had stopped and the Acres Mill shopping center. And so the flyover video, if I recall, it starts like at the intersection of Acres Mill going into the shopping center, and it flies over it, and it's slow and it gets closer and closer, and it shows like the building where the pizza place is, and it shows, you know, the street. It shows the car, the way that it was parked. I mean,
but it's from a bird's eye view.
From a bird's eye view, and then as it gets closer, you literally see the roof of the car hidden. It like disappears. It just kind of like just fades away, and then you can see this car seat, this animated car seat, and an animated child to represent Cooper sitting in the car seat
From above the car.
What's that? Above the car, right? And like the windows are removed. You can't see it. So it like creates this impression that the vehicle was like a convertible.
But you can clearly see through what was supposed to have been a roof, but you're getting angles that I guess a normal person wouldn't get.
Right.
Okay. Now, did they do any other views or anything other than that one?
Yeah. So the technology's pretty cool. Like, I mean, the scans that allowed them to create the flyover video also allow the witness, David Dustin, to use his iPad to control the view of this, of a certain vantage point within the scan. And that's also animated, simulated within the scan. So
Is
you
that from inside the vehicle?
go ahead.
Is that from inside the vehicle?
From inside the vehicle, from outside the vehicle, from like any vantage point within the scan, he can position it and then move the iPad around, almost like if the iPad were virtual reality goggles. And as you move around physically, you can see within the scene different perspectives.
And when what happens when they do a side view of the car, of Ross Harris's car?
What happens?
Yeah, what do you see? What can you see? And what did you see on the screen during your cross-examination?
So I don't think that I had him do the manipulated like virtual reality during my cross, but they definitely did it on direct.
Testimony. Excuse me, I'm sorry. I didn't mean to limit it to your cross of him. During his testimony, what did you see?
Yeah, so like they had, I can recall there being big on the Mondo board, like a close up inside the car with the passenger doors open, like a close up on the car seat and the doll. Just,
Were the
just
doors
focused in on that. What's that?
Were the doors open or were they removed?
Either they were open or removed. I mean, if what I recall is it was focused in beyond the doors. So it was like from a side view inside, focused on the child model and the seat.
So it was close up?
Yeah, it was, I mean, at different points, but yeah, I mean, I distinctly remember there being a close up. I want to say they were trying to show like how close the car seat was to the front passenger seats or where it was positioned in relation to the front passenger seats, something like that.
All right. Did you have, was there any device to get angles from the front driver's seat?
Yeah. So there was also as part of the scan, what David Dustin did was he put like a tripod inside the driver's seat. He positioned it on driver's seat, and then the head of the scanner, it moves, I guess like swivels, and it shoots out these lasers in all directions, and the laser bounces back. And it basically created this panoramic photo, 360-degree photo from inside the car from the driver's seat perspective.
All right. Now, what could that, if anything, could that panoramic view do that a human being couldn't?
Well, if you looked at the actual panoramic photo, it gave the impression. Well, it was from like the perspective of someone sitting backwards in the driver's seat, where you could see, directly behind you could see the headrest of the driver's seat, which obviously if you're sitting in the driver's seat, you can't see the headrest directly behind you. This panoramic photo showed the headrest, and it gave the misleading impression, I thought, that no matter what, you can see the child. You can see the car seat. You can see the model.
All right. And when they were setting up that monitor and they were testifying before the jury, did they talk about how the height or whatever to make the driver panoramic view, the eye angle for it?
Yeah, as I recall, David Dustin set the height of the scanner to be, approximately that of his eye level.
Of David Dustin's eye level?
David Dustin's.
Why did they choose David Dustin?
Because David Dustin was close in height to Ross Harris. I mean, they wanted to simulate the perspective of Ross Harris.
Did they give a reason for introducing this testimony or this 3D scan. Sorry.
I think to show spatial proximity between objects in the scene.
Okay.
Yeah.
Okay. Thank you. I don't have anything else at this time.
Can you hear me okay, Mr. Rodriguez?
Yes, ma'am. Good morning.
Morning. So with regard to cross-examining David Dustin, you had a strategy that you employed to go ahead and try and discredit the 3D, basically kind of a crime scene diagram. Is that right?
Well, I don't know about discredit it. I mean, it like I said, it's pretty cool technology. I just don't, the way that it was used was, I thought, to provide a misleading impression of what actually happened in reality.
And did you express that through your cross-examination?
I tried to.
All right. And with regard to Mr. Persinger, I noticed you said that the minute he was putting up some stuff that wasn't in his report, you pivoted right away.
Yeah. Tried.
Okay. And that's happened at trial. People all of a sudden start testifying to stuff you've never heard before, right?
It happens. Yeah.
And in this case, when you pivoted, I believe you strategically attempted to confront him and discredit him. Is that correct?
Yes. I tried to impeach him.
All right. And the reason you wanted to impeach him was you wanted to show he was biased by having selected this Griffin Psychology website.
Yes.
Okay. And you, in fact, did that. You brought that up to his attention and demonstrated that, didn't you, through cross-examination?
Not the way that I intended.
Best laid plans of mice and men, right?
That's right.
All right. And I want to draw your attention to August 10th of 2015. Did you have the occasion to go with Maddox Kilgore and Brian Lumpkin and Dr. Diamond to visit Ross Harris at the Cobb County Jail?
I think so.
Okay. This would have been the first time Dr. David Diamond came into Atlanta, and he was the first time he met with you and your team. And then I think you and your team took him out to the Cobb County Detention Center. Do you remember being there during that interview with your client?
Yeah. So I'm sorry. What's throwing me off is the August date. I definitely recall being with Mr. Diamond the first time that he came to Marietta and Cobb County, and we went to the Cobb County Jail to meet with Ross. I remember that.
Okay. And that very first time, did Dr. Diamond have his laptop with him?
I can't recall if he did.
Okay. What did you see or notice in any way that Dr. Diamond took notes regarding his interview with Ross Harris?
I don't remember him taking notes. I just remember us talking in the conference room.
Talking in the conference room?
Mm-hmm.
Did he have his laptop open to take notes on the laptop while you all were talking in the conference room?
I have no idea.
All right, and then I'm going to pivot now myself to November 3rd, 2016, while at trial. And this was the 29th day of testimony. The defense was presenting its defense, and Dr. Jean Brewer was on the stand. Do you recall Dr. Jean Brewer testifying?
Yes.
Okay, and who handled that direct examination for the defense?
Maddox.
All right, and do you recall at a lunch break meeting with Maddox, Mr. Lumpkin, and yourself to discuss whether to put Dr. Diamond on the stand or not?
No.
You don't recall doing that over lunch? Mm-hmm. Who made the decision about whether to call Dr. Diamond or not to the stand on November 3rd, 2016?
I don't know what date it was, but it would have been Maddox's call. He was the lead.
And do you recall seeing Dr. Diamond that day waiting to testify on November 3rd, 2016 in the courthouse?
I don't.
Do you remember meeting with Dr. Diamond at the end of that particular day of testimony?
I don't.
Do you remember that after Dr. Jean Brewer testified, there was a lunch break that Mr. Kilgore came back into the courtroom and announced that the defense had no more witnesses for that afternoon?
I don't recall that. I mean, I'm not saying that that didn't happen. I mean, that was a long trial. I don't remember vividly Maddox coming in and saying that we need to break for the day and Dr. Brewer being the last witness of the day. I just don't remember that. If that's how it went down, I don't dispute it. I mean, I think the transcript probably would. I mean, if you want to direct me to that, I could probably agree with you, but I just don't remember.
No, that's okay. I just wanted to know what your recollection was, and basically kind of how that day went. And if I may have one moment. I will pass the witness.
Ms. Durham, do you have anything further?
Everybody's microphone but my own. Sorry. Everybody's microphone but myself. Hey, Mr. Rodriguez, I just got a couple of questions. The state asked you about, it's at trials, sometimes you have to pivot and do things and when Mr. Persinger's regard, he came in with a litany of things that were not on his two-item checklist. How did you try to pivot in that?
Well, I then wanted to impeach that expert witness with all of the computer evidence, all the digital evidence that he would have had available to him that would have easily shown that his opinion about Ross being crafty and suspicious and clearing his cash and all this stuff, that was really just a fraud. And given the jury an opportunity, or not an opportunity, but given the jury a significantly different impression of his credibility.
And you were doing this, you're going to do this through cross-examination?
Absolutely.
So what were you trying, I mean, without trying to get into these things, but were you doing it to show anything on the lead investigator's behalf, anything he was trying to do improperly?
Well, yeah, I mean, like I said, it was either that he was intentionally misleading the jury about his level of thoroughness, or he didn't know and he was incompetent and not worthy of belief. I mean, either way, it was a biased investigation and his testimony was completely biased in favor of the state.
And you were trying to show that through your cross-examination of him?
But I certainly plan to.
And all right, thank you very much.
Nothing further from the state.
All right, thank you all.
I think it's a good time, obviously, to take a break for lunch. Let's recess until 1 o'clock. What do you need, Mr. Durham? Do you need something? I'm sorry.
Sorry.
I'm sorry, Judge. I couldn't hear what time we're recessing until.
Yeah, until 1.
Great, thank you.
But if you need, well, let me ask this. Mr. Durham, are you?
I was going to see if I could do 1:30, but okay. We're about to rest. We don't have any more witnesses, so we will be, unless the state has witnesses, we will be done today. So I was going to see if we come back at 1:30.
Does the state have witnesses?
No, Your Honor, the state has no witnesses.
Do you anticipate concluding your argument this afternoon, or what is your status, Mr. Durham?
What would I don't even know I had choices. So.
Well, I'll listen to you.
Oh, how long is it? That's just it. That's what I mean. I'm wanted to whittle it down now and try to make it more concise and a little bit.
Regardless, you need time to develop your argument. You're asking me for a little more time. We're on pace. I have no problem with following traditional hours and waiting until 1:30 for you all, so you can have a break and be developed and prepared for argument this afternoon. 1:30 is fine with me.
Thank you.
All right, very well. We're in recess until 1:30.
Thank you, Judge.
Absolutely. All right.
Hey, Ross.
Thank you, Mr. Evans.
Huh?
Hey, Carlos, what's up, man?
All right, let's have recess, everybody.
Mr. Boring, I want to get this right, on the 5th day of trial, on the September 16th hearing. So September 16th, 5th day of trial, right after voir dire is being conducted, you go ahead and you have this hearing. And Mr. Boring is repeatedly saying, I don't want work product. I don't want work product at all. And Mr. Boring is really smart. He's starting to think to himself, this is a trap. I can feel it coming. Paragraph 8 of the motion to reconsider says, well, court's order is too broad and attorney work product might be given and all this sort of, So Mr. Boring's thinking, you know what? This is a trap. I'm asking for specific certain things. All I want is Dr. David Diamond's notes, whatever he has to say about what Ross Harris said that he's basing his opinion on. I don't want any work product. And lo and behold, what does Maddox Kilgore specifically hand over to the state? What he claimed yesterday was attorney work product. And Mr. Boring knew that this was a trap. He knew it in here because he went and had another assistant district attorney in Brunswick review it. Why do you think he did that, Your Honor? He did that because he knew that this was a purposeful, intentional attempt to insert reversible error into this case. And that's exactly what Mr. Kilgore did. Because at that September 16th hearing, Mr. Kilgore was told repeatedly, we don't want attorney work product. We want these specific statements. And to basically go ahead and say, well, the court made me do it. I followed the court's ruling. I don't care what the state said they wanted. I did what the court said. And what the court said was, I stand by my ruling, all of it. And Judge, you know what you meant by that. You either meant, I stand by my ruling, all of it, all of my ruling. I stand by my ruling, all of the statements of Ross Harris given to Dr. Diamond that he was going to rely on, or I mean, give it all to them, including all of your work product. Problem is, Maddox Kilgore not once during that hearing mentioned that these statements included attorney work product. He did not tell you, he did not tell this court at any time on September 16th that these things existed within that statement or within those 3 pages. And if he had asked, well, Judge, I need it redacted, I need it in camera, we wouldn't have this issue. So this is built-in, attempted built-in reversible error by the defense. And we know that because Chuck Boring sensed it way back at the time of trial and had it reviewed. Now, having said all of that, this issue actually is not reviewable. And the reason it's not reviewable is this, Your Honor. When we have an instance where the court has made a ruling such as this, it is incumbent upon the defense to put the witness up, because the higher courts, such as yourself or the Supreme Court, cannot possibly review this as an error. And I cite to both McAllister and to Warbington. They're both listed in my brief. And basically what the Court of Appeals has explained in McAllister is this, that without the benefit of a witness testimony, such as Dr. Diamond, our review is entirely speculative when we do not know what the trial testimony would have been of Dr. Diamond. We don't know how the trial court might have altered its initial ruling as his testimony unfolded. We don't know how the state's cross-examination of the expert would have gone. Would it have gone as planned? Would something have happened? And even without these other difficulties, we are unable to conduct a harmless error review because we cannot discern the impact any allegedly erroneously admitted evidence would have had. So basically under McAllister and Warrington, there is absolutely nothing here to review. You made a ruling. We cannot determine whether it was erroneous or not because nothing actually happened based on your ruling. The defense went ahead and made a strategic, knowing, intelligent decision to not put up Dr. David Diamond. And while the defense is asserting that it was all because of this particular ruling, the state says no. The state says that's completely and totally untrue. And the reason we know that that's completely and totally untrue is because of the testimony of Maddox Kilgore. Maddox Kilgore testified that he went up to Dr. David Diamond afterwards and said, the reason we're not putting you on the stand is you could be subjected to cross-examination, especially about these things, where there's inconsistencies in testimony between your testimony and Dr. Brewer. with the state could go ahead and object to your testimony, especially when you're testifying, well, I interviewed some other woman who did this one time, and therefore that means Ross Harris did it. That's completely not allowed. And of course, the state would have objected to that. He gave a number of other reasons to Dr. Diamond for not calling him to the stand. Those are the real reasons, not the fact that the state had their hands on Dr. Diamond's notes. Not at all. So, Your Honor, our position here, number one, is the court was completely correct under the statute 1716-4 in compelling the defense to provide the state with what the state was entitled to. The defense is not allowed to put up a witness who opines, here's my opinion, and it's based on what the defendant told me, without telling the state what it is that the defendant told the expert that's the basis of his opinion. So first off, the court was completely correct legally in doing that. But most importantly, there's nothing for the court to rule upon. The court can't possibly know what the testimony at the time of trial would be. Now, while defense counsel went ahead and put up Dr. David Diamond, as I pointed out, this is 2020. Mr. Durham is not Maddox Kilgore. I am not Chuck Boring. And how Dr. Diamond's testimony would have unfolded, what the objections would have been, what the court's rulings would have been, are all unknowable to the court or to any appellate court. And therefore, under McAllister and Warbington, there's actually nothing for the court to review. Thank you.
Mr. Durham?
Yes, Judge. I can say we do live in the age of expansive conspiracy theories. The idea that this was some plot by these scheming defense attorneys is just beyond all realm of possibility to me. It's clear on the record what happened. The state wanted something they couldn't get, or maybe they thought they could get it, but they tried to do it through the legal avenue. And also, I do want to point out, there's a massive amount of speculations of what Chuck Boring knows and what he didn't know. And it's all just speculation. But regardless of what the record shows us is, he found out that there were some notes that Dr. Diamond had. There's nothing in the record of the conversation between Chuck Boring and Dr. Diamond. We don't know what Chuck Boring's recollection of that hearing was, or a recollection of what that conversation was. We just have speculation on it. And that speculation is devolved into this huge conspiracy that Maddox Kilgore and the trial team were conspiring to have the case reversed by some miraculous way, and I guess get their client convicted and then hope to get a new trial. It's not the greatest strategy in the world, but we're going to go with it for this argument anyway. Now, the thing that does need to be pointed out is the order in this case that says any materials relating to any regard and in any manner. There was just any and all. It was so broad, and that was submitted by Chuck Boring. Maddox Kilgore told him at the very first hearing that it was a work product. He said that during the hearing. It was verbal, and he said it. Nobody cared. They didn't care. Chuck Boring went ahead on the record and went forward and issued the order any and all without any regard to the work product concern that Maddox Kilgore said orally. Next hearing, Mr. Kilgore puts it down in the pleading and he writes it down. So I don't know how I can explain it any better, but it was at some point, the state's got to take blame for taking this order, expanding what the trial court said at the initial hearing and making it a little bit broader, where any and all and in any manner and in any regard. And so they had to turn over everything. You do have something to review. You have Dr. Diamond's testimony. I can't find my little McAllister case here, but my recollection on McAllister is it does say some of the things, but there's also a notation in McAllister that a footnote that notes that An ineffective claim was not proffered, which means that there was no proffer at the motion for new trial. And so you have that here. Yes, I am not Maddox Kilgore, but you still have a proffer. It still needs to be considered. There is something to review, and it shows the harm, and it shows that, and you can look at the document that he was forced to turn over. He asked not to have to do it, and even Chuck Boring started realizing, according to the record, and the way it reads, he was having issues about maybe I went a little too far, and maybe they're right, but he didn't ask the court for an in-camera. He did ask the court if they consider redaction. Your Honor said no, and the defense wasn't even allowed to redact it. Now, at no point did Mr. Boring, there's any record of Mr. Boring coming in saying, well, listen, why don't y'all just get me a summary, get me a redaction or something like this, but he didn't. He went with his order, and it was too broadly written and got information that he wasn't supposed to. And instead of asking the court for an in-camera, he has a DA do the in-camera. And the funny thing is they gave him the wrong stuff. They gave him the work product. So to make this into some type of conspiracy theory that the defense is trying to sabotage Mr. Harris and get him convicted in hopes they can get for a new trial is a little bit far-fetched. And you do have the evidence presented to make the consideration. You have the evidence laid out for you of what was turned over, and you have a law that says it wasn't required. And we respectfully ask you to grant our motion.
Let's move to the next matter.
Okay. I think the only one I have left is the 3D.
That's consistent with what you said.
Judge, if I could do one more thing. I dropped this note. Also, in response to that, there was an order about the ultimate issue where the opinions couldn't be testified to in that time frame of 2016. We were just kind of coming in with a new code section, and ultimate issue was not a lawful way for him to testify anyway. The court granted it, so the idea that he could come in and state his opinion at the trial was incorrect, especially in light of the judge's order. All right, if I can, I'll just go ahead and go with the cartoon. This one may not be as long, but I do want to put some factual things on it and make it a little bit more cohesive. And I think the state's idea about being able to see the video if the court needs to may be helpful. Your recollection may be sufficient. I'll leave that to the court, but I think it did help me and understand the case a little better. The background of this was these motions were heard last year about the 3D animation, and the defense objected to it. The court allowed it. It was allowed a rejection, and the objections were, state says it's demonstrative, and it's only there to show the spatial proximity of things and like that. And the defense said, well, it's going to be misused, and it's, that was one of the arguments. Another one was it's not aiding any witness in any demonstration. So, and there was other arguments there, but that's the gist of it. That's a nice summary. Anyway, the court comes in and allows it in. We go to trial. Now, understand again, one of the big issues for the defense is they have all this massive evidence coming in of bad characters, and these other things coming in, and an accident alone may not get it. So they're trying their best to discredit the police, to show their bias and motive about trying to slant evidence in their favor and to try to better the theory of their case. And again, that was brought out during the cross-examination of the defense counsel during this motion for new trial. Well, in this, they get this 3D animation and they review it and they nitpick it. And T. Brian Lumpkin comes in and I don't know if he's got his own little measuring stick or whatever, but he goes through this meticulously. And when they go to, and again, it's part of their defense theory is to attack the state. And so they go to trial and they bring it to trial. We're in a month into the trial and the state creates a new one. Because what happened was, I believe it was Officer Grinstead gets on the stand during trial, and it is learned that some measurements were off or they weren't used properly, and also the seat extension was not in the same place. It was when Cooper died, it was not in, it was in a different spot than when the 3D cartoon was created. So they're like, oh man, this whole thing is off. And now this is something at the hearing, in the motion hearing, Mr. Dustin gets up and testifies and raises his little right hand and says he swears or affirms that this evidence is a true and accurate replication. Well, that's what he testified to. It wasn't. So they all of a sudden in the middle of the trial, while everything else is going on, the defense gets tapped on the shoulder and they say, hey, here's a new 3D animation. They didn't know anybody knew it was going to happen. They took the evidence, the car seat, to the garage and had Mr. Grimstead come and redo the measurements. Mr. Dunson come and do his scanning magic again. And then all of a sudden, defense is getting this little exhibit in their hand that they haven't had a chance to see. And they had been preparing their whole defense of attacking and trying to destroy the bias and motive of the state and go after their credibility. And all of a sudden, one of their arguments goes away because now, okay, we got caught. We're going to go ahead now and give a more accurate one. So one, we're saying that it was a discovery violation because not only wasn't it done before trial, but it was done like a month into trial. So we now go to the 3D animation itself. Numerous times during the hearing, Mr. Dunstan admitted that, look, I'm only swearing that it is a true and accurate representation of the stage that was set up for me. He doesn't know anything about the case. He's been shown a few pictures and that's about it. But he wasn't there at the scene, and he didn't do measurements. He just, again, they set it up, I come in and I do my thing, and that's all it's a true and accurate representation of. So he gets on the stand and he again says, this is a true and accurate representation of what it was staged for me this week. And so, but not of the scene. Another thing I'd like the court to recall is during his cross-examination, I think it was at the very end, Carlos Rodriguez is asking him, he says, well, did you know anything about the witnesses where this car was parked walking by it? And, you know, you had the windows down on the 3D, the windows are down, so you can see through it now. And of course, Mr. Dunstan said he did not know anything about the evidence of people walking by because he didn't know anything about the case. And the question was, well, then it wouldn't be a true and accurate representation of that, would it? And Mr. Dunstan said, no, it would not. That is the concern. The issue we have, also another issue is how misleading it is. And I think, well, the court's going to recall this better, but there was, you know, some evidence put out today, but the flyovers, the ability to take the roof off, the windows down, and to manipulate it where you can see in places that you've never seen before. And all of this is supposed to be for the issue of spatial proximity. But they also make sure the jury knows that, hey, we're trying to do this just so it'll be what Ross Harris can see. We're going to get the guy closest to his height to sit in the chair, and we're going to put the tape there and have that at his eye level. And then that'll be more accurate. But then they get this machine that can spin its head around. It does 360 degrees and see things that a human being can't. So it is inviting the jury to exchange their views for what Ross Harris can see. And I hope the court understands and appreciates what a critical thing that is, because a key fact that they have to determine is what Ross Harris saw when he got out of that car. And when you can have a video where your head can turn around in angles it's never seen before, that is persuasive, it's devastating, it's, more importantly, it's prejudicial. So also bear in mind that they had pictures and pictures and pictures, all different angles. They got to see the car. They went out to the vehicle themselves. So I do think it's prejudicial. And one other thing they keep talking about in the motion hearings, that it was only to show spatial proximity, but during, I think it might have been redirect or direct, but there was testimony where the state is saying you can see his feet there. And, of course, the answer was yes, because you could, but you had to be looking for it. So we would ask the court to, look at that again. And what I'd cite, Your Honor, is if the court would look at, the demonstrative aid. I'm looking at page 268 of millage, and there's two basic rules here. Those two rules are that you, a witness with personal knowledge of the real evidence must testify that the demonstrative exhibit is a fair and accurate representation of the real evidence in all material aspects. That was not done here because, I would submit anyway, it's not done here because Mr. Dunstan knows nothing about the real evidence. Mr. Dunstan's testifying that he knows that this was a true and accurate representation of what was staged to him. So we think it falls on that regard. And the example in Millage's case is where it was a person that knew the intersection, been there, and was able to do a diagram about that. Mr. Dunstan hasn't been there. He doesn't know about the case. He's been shown a few pictures. So we don't think the first peg of is met. The second requirement is that the demonstrative exhibit must be sufficiently probative and helpful, and have outweigh any tendencies of the exhibit's ability to confuse and mislead the jury. And they, under the new code section, I say it's new, it's 2013. So, but there's a Smith case that decided, and it is at 299 Georgia 424. And in Smith, they did allow, and I believe Smith is the one where it was a medical examiner had a doll, and he was going to try to show how the child had died, and how he thinks the injuries were brought about. He's a professional medical expert. This is what he does, and he was using this doll as a demonstrative exhibit. So they allowed that. That's not what happened in this case. I'd submit what in this case is, you don't have an expert witness that's trying to tell you anything about the evidence. What Mr. Dunstan is he's an expert, but his expertise is in making 3D animations. So it has nothing to do with the furtherance of the real evidence in the case. He's not aiding in any demonstration about the trial. And so when you're allowing him to do that, I think, it's just, again, the jury is going to be in such a danger of being misled that I believe that the second prong here should not have been allowed. Also cite the court to U.S. v. Gaskell, Gaskell, it's 985 Fed Second 1056. And again, it just said, I think in Gaskell, the evidence was actually not material, similar enough in materiality, but it was, it was another doll case, I believe. So, but the cases that have been used, and they're using these demonstrative aids, there's got to be something, an aid to some witness. And Mr. Johnson is not a witness. All he can do is testify to what somebody else told him. That's what the state somebody else put up. So for those things, we'd ask the court to reconsider allowing that in and grant us the relief. Thank you.
Thank you, Your Honor. Your Honor, regarding the 3D crime scene diagram, because let's face it, that's really what it is. It's the future of crime scene diagrams. We all know that we used to have a detective who would go out to the scene, who couldn't draw, and would draw these terrible little hand drawings in a notebook and put dimensions on it. And we would tender it in a trial going so that, the jury could kind of get a feel for what the crime scene looked like. And it was an overhead flyover view, an aerial view down of the crime scene based on measurements taken. This is just the future. Just like we used to take photos with film and now it's digital. Just like now we actually sometimes take video of a crime scene so that the jury can see it. This is just the future of crime scene diagrams. That's all it is. And with our evidence code, a lot of the cases cited during the original arguments are no longer valid cases and have been specifically actually overruled by Rickman versus the state. 304 Georgia 61, a 2018 case holding that the admission of demonstrative evidence is not controlled by cases decided under the old evidence code, such as Pricken, P-I-C-K-R-E-N, and Eland, E-I-L-A-N-D. And the thing about the Rickman case that's really interesting is that they said it was absolutely fine for the police department to go out during the day with different cars to reenact the crime scene and to reenact what took place during the crime. And they said that was fine. And one of the reasons it's fine, Your Honor, is because when you tell the jury, here are the caveats. Here's what we did, here's why we did it, and here's what's kind of wrong with it, here's what might not be accurate with it, then you explain to the jury why you're doing it and what it's there for. And that took place in this case. David Dustin is the tech guy. He's just the tech guy. That would be like complaining that the cameraman took the photos. The person who goes, yeah, these are fair and accurate photos of the crime scene as I saw them, might be the detective. But the tech person is the actual one with the camera who went and took some nice photos. Okay. But as long as somebody can testify that this is fair and accurate, which Detective Grimstead did, he got on the stand. He talked all about what they did in order to do these scans. Detective Stoddard had testified about what he had done to do the original scans. So all of this testimony was before the jury so they understood the limitations of this type of evidence. And it's just a crime scene diagram in 3D that somebody can move around, they can look at it. And the idea that it's misleading is disingenuous, I believe, because let's face it, as Mr. Rodriguez says, it's like a video game. And most people are familiar with video games. Most jurors are sophisticated. Most jurors have seen Star Wars, Blade Runner, all kinds of science fiction movies, including Disney animated movies, and they understand what it is they're looking at. And they understand what a bird's eye view is. They don't believe that a human being saw a bird's eye view. They know that. They know what this is. A lot of them have been to IMAX movies. They understand that that's not how the bird flies or what the bird sees. So I think it's disingenuous to say the jury's misled. The jury understands what it's looking at, and they understood from David Dustin the limitations because he was cross-examined extensively about it. It is unfortunate that this was the last witness of the trial. But the reason he was the last witness of the trial is the state figured out, Detective Grimstead made a mistake. And he's on the stand, he's talking about it, and it's like, oh my gosh, the measurements are wrong. We have to rescan because we've got to do it right. So it's very similar to a detective looking at their crime scene diagram going, oh my gosh, I wrote 13 feet down, but it was really 14 feet. And redoing his crime scene diagram and going, oh, here, defense, I fixed this because I testified at trial that I did it wrong, and here's the right number on it. That's the exact same thing that happened. So as far as the discovery violation, they knew all about these 3D crime scene diagrams. And there were numerous ones, not just the one of the car that had to be redone because of the car seat. They had seen all of them. And what we did, the state, is we corrected an error made by Grimstead. And he got cross-examined about it extensively. As was pointed out by Mr. Durham, both the old scans and the new scans were all put into evidence so that the jury knew, yeah, Grimstead screwed up and we had to redo it. Thus, attacking the credibility of the state, and the jury could do what they wanted with that information. But in this case, it is not a discovery violation. They knew all about it. What they got was a corrected version of the scan. The court was correct in allowing it in as demonstrative evidence because it's appropriate. It's there to aid the jury. Just because it came at the end after everyone had testified doesn't mean it didn't help the jury understand their testimony when they saw the 3D crime scene. So it was helpful to the jury. It helped illustrate the testimony that had already taken place. It was appropriate to allow it in because it is helpful. The court did do a 403 analysis on it, and that's in the court's order. So that was taken care of. And to criticize David Dustin, he's just the tech guy who put it together. Him authenticating it and explaining how it works is completely different than Detective Grimstead, Detective Stoddard talking about the crime scene and authenticating what they had done to work with David Dustin in order to do the scans, in order to present that demonstrative evidence to the jury. And in this case, the statutes that do control will be 401, 403, 611, and 901. And all of those were checked off appropriately by the court. Thank you, Your Honor.
I'll be brief, Judge. First off, I do want to be clear. I do not mean any disrespect whatsoever. I did not mean to be criticizing David Dustin. I was criticizing the state. But and what it is, Judge, is this is demonstrative aid. It's supposed to aid a witness in his testimony. David Dustin's testimony was, I did a scan. And I did a scan of a scene that somebody staged. It didn't have anything to do with the trial. His testimony may have been come in to lay the foundation if another witness had gotten up there and testified using it, and it aided that witness as somebody that had knowledge of the case and was working on the case and had something pertinent to say about the case, and it aided their testimony. But all of David, they may have needed him to lay the foundation of how it works, but this exhibit did not aid his testimony one iota. And I don't, I just do want to point out that the state figured it out when it was pointed out to him on cross-examination. And, they shouldn't have been allowed to correct it, quite honestly, because this was something they were going to use. Everybody had been prepared for it. Everybody had worked on this case for years, getting it ready. The defense had relied on this, put their and had that as part of their theory of defense. And then it's all sudden taken out from them, and because the state's allowed to come in and just recreate something in the middle of the trial. We'd stand by the arguments, and thank you for your time.
Mr. Durham, I think that concludes the points you wanted to make. Am I correct or am I incorrect?
Right now, you're correct.
Well, I know you're going to want to respond to the state's matters. So, of course, that's not what I wasn't asking that. All right, let's move to the state then.
Thank you, Your Honor. What the state wished to address were the two, let's make sure I get this correct, the two amended motion for new trial assertions of error due to ineffective assistance of counsel. And in the amended motion for new trial, the defendant submits that that trial counsel provided ineffective assistance of counsel by failing to call Dr. David Diamond as an expert witness at trial. Your Honor, the state submits that that is not the case whatsoever. It's not a failure to call Dr. David Diamond as an expert witness being ineffective. That is a strategic, knowing, and intelligent decision. And it was made by Maddox Kilgore. As he repeatedly said today, he's the one who pulled the trigger on that. He's the one who made that decision. He testified that he thought he made it the night before Dr. Gene Brewer testified. However, Dr. Diamond testified he was at the courthouse, ready to testify, had come in the night before, and that they came up and they told him, oh yeah, you're not going to testify. So he had been prepared and he was ready and he was at the courthouse. and they told him he was not going to be prepared to testify. As the trial transcript reflects, Mr. Kilgore actually asked the court to have a lunch break so he could discuss with the other attorneys, and he actually said, and with the witness, and that would be Dr. Diamond, to discuss exactly whether he was going to put Dr. Diamond up or not. And that's what he did. He made a strategic, knowing, and intelligent decision about who to call and who not to call. Now, he does try and blame the trial court. I was forced to not call this witness. I was forced to hand over these confidential work product notes that he keeps talking about. Even though the state never asked for those, even though the state said they didn't want those, he handed them over, and he handed them over knowingly and intelligently and purposely in the state's position. But the real issue here, Your Honor, is there were so many other factors that went into Mr. Kilgore deciding not to call David Diamond. And those included the fact that the court appropriately had ruled Dr. Diamond could not opine to the ultimate issue under 704. The court had appropriately ruled that Dr. Diamond could not be used as a conduit for self-serving hearsay statements from the defendant. Mr. Kilgore knew the defense was going to object to the majority of the slides. And the thing is, Dr. Jean Brewer got up and testified to every single thing that Dr. Diamond was going to testify to. So the defense got to put up that expert they had promised from opening. What he was going to testify to was the ultimate issue, but all of a sudden that got knocked out. And so Mr. Kilgore testified. Well, I then wanted him to testify about his personal knowledge, and he was going to do that by comparing cases. He was going to put up a slide, as you saw in, I want to make sure I get this correct and tell you which defense exhibit. Defense 3, the 50-slide PowerPoint presentation. He was going to put up a media story about an airplane crash. He was going to put up the stories about officers leaving guns in restrooms. But we all know he wouldn't be able to testify to, I talked to that officer and that officer told me. That's immediate hearsay. So that would not have been allowed at all. And then they put in slides about Lynn Balfour. Some woman 20 years ago left her kid in the car, and she said, these are the reasons why she did it. And Ross Harris says, these are the reasons what he did. So obviously he must have done the same thing. That is never allowed. That's so objectionable. I mean, I'm sure I don't even need to give the court examples of a forensic interviewer doing something like that or a gang expert for the state doing something like that. The defense would never, ever allow that. They'd be jumping up and down, screaming with objections. So we have a couple of issues. Dr. Diamond was actually going to testify to something diametrically opposed to what Dr. Brewer testified to. And I'm just going to give you one of those examples. And one of those examples is the cues. Dr. Brewer got on the stand, and there was 2 pages of cross-examination by Mr. Boring saying, isn't this a cue? Isn't this a cue? Isn't this a cue for Mr. Harris to have remembered that Cooper was in the car? And Dr. Jean Brewer goes, yeah, that's a cue, that's a cue, that's a cue, including the Chick-fil-A cup. Yesterday morning, Dr. Diamond testified that his testimony would have been, there were no cues. So when you have 2 experts who take the stand and say something completely opposite, that is complete fodder for the state to basically make a huge argument that you can't believe either one of them because the 2 of them can't decide what's a cue and what's not a cue. So when you've already put up a witness and they've testified to one thing, you don't want to put up a second witness who says something that's the exact opposite. And so there are numerous reasons, including the headline news article. Dr. Diamond was going to be attacked with that immediately on June 30th. This murder happened June 18th. On June 30th, this Dr. Diamond is talking to headline news about this case. So how do you say you're fair and impartial and an expert who's just doing an analysis when you've already made up a decision within 2 to 3 weeks of the incident taking place? So those were all things that were going to take place on the cross-examination of Dr. Diamond and why the defense strategically and knowingly decided to not put him up. So therefore, we think there's absolutely no basis to find that Maddox Kilgore and the other attorneys were ineffective by not calling Dr. Diamond as an expert witness at trial. And that concludes part 1. There is part 2, but I will let Mr. Durham respond.
Okay. First off, the notes were handed over at the direction of the court. It wasn't like he just, here, take these. The court ordered him to do it, and the court had to order him twice because he was ordered the first time. Is like, no, this is wrong. You need to reconsider this, and comes back in. So he tried to fight that. So in the as far as the PowerPoint goes, I think the evidence is clear, and there's also spots in the spot in the records where they do talk about that. And Mr. Boring said that, and this was during the trial, he said that he's gotten it. There was numerous objections, but they were working, and this was a work in progress, and they were working through this. And there were, I mean, so some of those were going to be cut out, and then they may give them with a resolution, but otherwise the judge would have made the decisions of whether or not the slides could come in. I think I would disagree that experts cannot testify as to hearsay. I think sometimes they can. I think it's a lot depends on what field they're in and these other aspects. But experts definitely would say that Dr. Diamond could testify to a good portion of the PowerPoint and maybe not the slides. But I think if the hearsay is something that somebody in his field reasonably relies on when reviewing and making conclusions and determinations, I think it'd be allowed. As far as the Dr. Brewer taking his place, Dr. Brewer admitted in his trial testimony that he is not Dr. David Diamond. He referred to during cross-examination, listen, David Diamond's the guy, whenever I have a case like this, I go to him. I mean, he's the one. And so Brewer acknowledged that. So we would submit there wouldn't be any confusion over for a jury which one to believe. Dr. Diamond is a national expert, and it would have been a completely different case if you'd have gone through and you'd asked the questions like, would it be a Q, would it be a Q, would it be a Q? Because that's exactly what Dr. Brewer told you. You need to go to David Diamond. He's the one that knows this. And I believe the CNN article was submitted into evidence. Court can review it. I don't believe Dr. Diamond made any conclusions about that. I believe the article was primarily about another case, and there was just some little blurb or some addition with Ross Harris's case, and it was just more of a factual thing about, this is something that happens a lot, children being left in cars. It didn't say whether or not it was an accident. It did not say whether it was intentional. I don't believe, if I remember reading right, and we're talking about the same article, I don't believe it made any mention of that. And as far as the ineffective claim, we would submit that if he, being Maddox Kilgore, relied on an incorrect legal belief, and he was so certain in it that he put his stock in that he wouldn't have to give those notes over that cost him his best witness, then he would be ineffective because they set the whole case up for the accident with Dr. Diamond in mind. If he's wrong in telling Dr. Diamond, hey, go ahead, your work product is going to be confidential, he could be ineffective because he cost the defense Dr. Diamond, and that was their key linchpin for the accident defense. If we go back to the motion to compel, if Maddox Kilgore is part of some huge conspiracy where they're going to try to intentionally set this up where Ross Harris would be convicted and try to get a motion for a new trial, then he would be ineffective for that as well. So we'd like the court to consider those things.
All right.
Thank you, Judge. And just to clarify, the state doesn't believe that the defense attorneys threw the trial. These defense attorneys fought tooth and nail, but these defense attorneys, meaning Mr. Kilgore, knowingly handed over what he claims is attorney work product, knowing the state didn't want attorney work product. The state wanted something very, very specific. The statements of Ross Harris given to Dr. Diamond that Dr. Diamond was going to use as the basis for his opinion. And I get that the defense is blaming the state for asking for that. And then be careful what you ask for. We're going to give you something you didn't ask for and then go, oh, it's reversible error. That's what the state's saying. These attorneys fought tooth and nail for Ross Harris. Did an excellent job for him. And so they were not ineffective in any way, shape, or form. I just want that to be clear about that particular argument. With regard to argument number 2, defendant submits that trial counsel was ineffective for relying on their belief that certain evidence would be admissible at trial and making this the basis of their defense. And in opening statements, Mr. Kilgore did go on and on and on 7 different times, mentioned Detective Stoddard, and did call him a liar. And the state takes exception with that, and takes exception with the demeanor and tone and attitude of Mr. Kilgore at this motion for new trial hearing. He repeatedly accused law enforcement of lying as if that was some sort of fact, and that is not the case whatsoever. However, that sort of demeanor goes to his credibility, and I'm assuming the court will make a credibility determination based on that. However, in this case, he did in opening go, we're going to go ahead and attack Detective Stoddard. We're going to show he lied, he misrepresented, that this wasn't right, that this wasn't right. And he had the opportunity to do that. 7 different places in opening statement, he talks about Detective Stoddard. And Detective Stoddard was on the stand for 4 days. Maddox Kilgore admitted, yes, I did a great cross-examination of him. In fact, I think he said he destroyed him. And he also said, I think that they destroyed Detective Grimstead. So in his opinion, they did a great job of destroying law enforcement and achieving their goal, which is the second prong of getting, questioning the credibility of law enforcement in this particular case. But here, defense is trying to say that Mr. Lumpkin and Mr. Kilgore were ineffective because in opening statements, they referred to the fact that the jury was going to hear about someone who lied about search warrants. And in the search warrants claimed that Ross Harris did research when Ross Harris didn't do research at all. And that's what the real issue here is. And so they say here in opening statements, defense counsel laid the groundwork by informing the jury that the police department made numerous false or misleading statements, including but not limited to statements made to the magistrate court when seeking search warrants. So what are they talking about? They're really talking about Sean Murphy. State didn't put Sean Murphy up. Sean Murphy wasn't the lead detective. Sean Murphy did a lot of peripheral things, and Detective Stoddard spent about 20 pages telling the jury everything Detective Murphy had done. The defense decided to call Detective Murphy with one thing in mind. One thing in mind. We're going to put him up there to destroy his credibility. Okay. Well, actually, what Mr. Lumpkin said was, we're going to put him up there to destroy the credibility of the entire police department. Well, you can't do that. That's not appropriate attacks on credibility. And the state has listed that out in our brief under that appropriate section for Sean Murphy about how you do appropriately attack the credibility of a witness. But in this case, saying Mr. Lumpkin or Mr. Kilgore are ineffective for attempting to get evidence in front of a jury they think is good evidence for their case, that's actually being a really good lawyer. That's what lawyers are supposed to do. They're supposed to put evidence before the jury, especially defense attorneys. They're supposed to put evidence up there that they think is really, really good evidence that's really, really going to make their case. If it turns out that, hey, the rules of evidence don't allow you to do that, and the judge rules, the rules of evidence don't allow you to put hearsay before the jury, especially when it comes to some guy saying, I told a magistrate judge this based on a bunch of hearsay other people told me, to be called then, well, you lied. That's an unfair characterization. And by the way, the statute doesn't allow you to do that. To claim that these attorneys were ineffective because they attempted to get what they thought was some good evidence before the jury, but it just so happens, hey, the rules of evidence don't allow you to do it this way, that's not ineffective. That's actually zealous advocacy. And we ask that you find that they were not ineffective for attempting to put up this evidence about Sean Murphy. Thank you.
And I can understand, trying to get something in and be denied. God knows I'm used to it, but their whole defense, their whole, good portion of their opening statement, everything was relying on this. And if you get up there in opening and you tell the jury that we're going to show you this guy's lied, the police department's lied, the police department's done this, you better be able to back it up. And he was not able to, because he was not able to get it. Not that it didn't happen, or there was incorrect statements on those on those search warrants, but he could put the evidence to fulfill his promise to the jury. I'm going to show you these things, and it would benefit the jury to determine if he did it. But if you can't even show him the evidence, then that is his fault. If he was so incorrect in his understanding of the hearsay rule and his assessment of evidentiary law, then and to make this big reliance on it, then he would be it could be determined to be he was ineffective, because he put so many eggs in that basket, and he had no basis for it, because you hear the state's argument. Well, this is just so common. I mean, it's just, everybody knows this. This is a hearsay thing. It's an evidentiary rule, and if he's that wrong, then that's before we would be submitting that he would be ineffective, and especially considering that he spent so much time, or the whole defense team did it, and it was all so reliant on this. We'll say, though, that the only reason they called Detective Murphy is because they couldn't cross-examine Stoddard. We've already made it, so that was why that happened. But I do want to point out, I mean, it may be too early to, it probably is, so I'll just wait. But that'll be it. Thank you.
In response, Judge, yes, the defense had a strategy of attacking the credibility of the law enforcement officers. Murphy was one of many who took the stand. And the main focus from opening to closing was Detective Stoddard, the lead detective in this case. So to say that this is error, if it is error, it's harmless error, because let's face it, it was such a small portion. It was one part of the opening, which took place October 5th of 2016, and the closings took place, I think, November 7th. So about a month later. So to say they didn't fulfill their promise because they couldn't put Detective Murphy up and it was ineffective because they believed it, this was not the main focus of the case. Detective Murphy was a small peripheral part, and they wanted to go ahead and attack him in order to attack the entire police force and the entire investigation. And it's not appropriate. It was a good strategy, and they went for it. Zealous advocacy. We ask that you deny this enumeration of error number 2 for ineffective assistance of counsel in the amended motion for new trial. Thank you.
Does that conclude our arguments?
Yes, Judge, it does from the state. Thank you.
For the defense? You're muted, Mr. Durham.
Technology. Now you know why I don't like the 3D. I didn't know if y'all were going. I thought she was going to. The state was going to say something about the adding the information as far as attacking the defense. When we were going down the list of cases of the enumerations, and I came to 17, 18, and 19. We put in 3 federal cases about it being unable to present the defense. And I thought, it's my understanding that Ms. Dunikowski was going to add something today. Was I wrong?
My understanding, and correct me if I'm wrong, was that she wanted to review the cases and then respond to that in writing.
Okay.
That's correct, Judge.
Okay. Then I did understand. Will I be able to respond to her response?
Of course.
Okay. Then I'll be quiet today.
Let her do it first. How long do you need to do that, Ms. Dunikowski?
Looking at a calendar. Day. I believe I'd be able to get it completed by the 23rd of this month.
All right. Mr. Durham, how long do you need after that?
10 days, or is that right? I mean, 5, whatever the court says, I'll work really hard.
By the end of the year? Or is that too tight?
I didn't hear you. I'm sorry.
I'm sorry. By the end of the year, or is that too tight?
Oh, that'd be fine. That'd be fine. Yeah.
All right. And then I'd like yes, I'm sorry.
Well, I was just thinking of it, but I was thinking about the holidays, but I just kind of realized that I'm gonna be stuck at home during the holidays. So I guess I'll be okay at the end of the year.
Well, I hope you're going to do something more fun than be stuck at home. Family. Well, I guess a family has to be across the room from us.
Yeah, that's.
If you get in trouble,
I have a translator here, Your Honor. I'm sorry.
I know. Well, here, heck with it. Try for the end of the year. If you need more time, you're welcome to it. In fact, do it the first week of the year.
Okay, that'd be fine. I really appreciate it. Thank you.
Well, I mean, I'm being selfish. I'm going to take a little time off too, or work in the office and get things cleared up and in good tight shape. I'd like proposed orders. let's say by January the 15th, is the 15th a weekday? Somebody with a calendar?
The Friday.
Well, Fridays are good. Does that work?
Yes, Judge.
Very
Yes,
good. Proposed orders by January 15th.
All right, Judge.
And again, if y'all run into trouble, call my office. I'll work with you. Is there anything else for the state?
Nothing for the state, Your Honor.
Is there anything else for the defense?
Not at this time, Judge.
All right, so my pleasure to work with you, and we'll be in recess on this case because I think I've got a calendar on something else. All right, thank you all.
Thank you.
Judge.
Audrey, what's happening with the Revo calendar? Okay, good. While you get that set up, I'll take a short recess. Everybody can have a little bit of a break. What is it?